The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. People versus Eugenio Cardenas is submitted. Clark versus Fedex Corporation, 4-1 for the appellant, 4 for the respondent. 2 matters with VP children. For the appellant, Shelly Rodriguez, 6-1. For Administration for Children's Services, 4. For the children, 1. For the appellant, Erickson Polanco, 2-1. For Administration for Children's Services, 4. For the children, 1. I'm going to be calling that matter together. So Administration for Children's Services, you're going to have 8 minutes essentially, and then 1 minute for each child. Wong versus Wong. For the appellant, 5-1. For the respondent, 5-1. Mira versus Morrison Cohen. For the appellant, 6-1. For the respondent, 6. Reese versus the City of New York. The appellant is not present. It's submitted. The respondent, if there is no appellant, I'm not going to give you 6-1. Obviously, I'm going to reduce the time. I'll give you 3 minutes.
Thank you. I have a cross appeal. Just want to note.
But you're the only one arguing right now. The other party is not present, so it's submitted. Elberg versus Crabapple. Again, I have no appellant, so it's a submission for the appellant. For the respondent, I'll give you 2 minutes. Landon C. versus Thread Council. The appellant, 6-1. For the respondent, 6 minutes. People versus Pedro Navarro is submitted. Goyard, New York versus Freeland Properties. For the appellant, 5-1. For the respondent, 5. Aviation Distributors versus Aviation Distributors. For the appellant, 6-3. For the respondent, Aviation, 5 minutes. For the respondent, Community, 5 minutes. Healy versus Healy versus BOP 1 North. For the appellant, 5-1. For the respondent, JT Megan, 3. For the respondent, BOP 1 North is 5-1. FM versus 42 West 35th Street property. For the appellant, 5-1. For the respondent, 5 minutes. Hughes versus New York City Loft Board. For the appellant, 5-1. For the respondent, Dasa Realty, 3 minutes. For the respondent, New York City Loft Board, 2 minutes. Catania versus Liriano. For the appellant, 5-1. For the respondent, 5 minutes. Neo Barak versus West 54-7 LLC is submitted. Cabrera versus Bay Park Center is submitted. 3 cases will be called out of order. Number 7, Reese versus the City of New York, will be called at the end of the calendar, as will Wong versus Wong and Mira versus Morrison Cohen. They will be called at the end of the calendar because certain justices are recused. As always, counsel, please remember that we have your briefs, we have the record, we are fully familiar with the facts of your cases, so please go directly to the important points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. That, of course, is particularly important during our virtual arguments, rather, so that we can hear the question that's being asked and that you can hear we can hear your responses. And finally, please keep your mics muted until your case is called. Thank you for your patience and your cooperation. First case for argument is Clark versus Fedex Corporation. You may begin.
May it please the court. My name is David Lowe. We represent Fedex in this appeal. Thank you for your time. Our position is that Arlene and Herbert Clark their claim is effectively a claim against Fedex relating to the injuries suffered by Debbie Clark. And their description.
So let me just, may I ask you, here they're seeking loss of services. Is there more to this than just an employer-employee relationship? I mean, she's the child of the parties who own the business, who have been working where she was working for some time, and the building was going to be, I'm sorry, the business was going to be presumably sold to her. Is there more to this relationship than a mere employee-employee relationship?
A couple of things, Your Honor. Thank you very much. That's a good question. First of all, the claim is effectively all economic damages, right? It's a claim for an inability to work in the family business, an inability to take over the family business, the support for her parents arising from some loss of income or loss of profits relating to that business. Those are all economic in nature, right? The other aspect that we would like to emphasize is the fact that Mr. and Mrs. Clark, Herbert Clark, Arlene Clark, they are the business, right? One business is an S corporation, the other one is a C corporation. So there's really no difference between the fact that they happen to be loving parents, of course, of Debbie Clark, but they are in effect tantamount to the business in and of itself. So this is really, from our perspective, a claim for the business on behalf of the business, clothed in a claim for loss of services by the mother and the father.
Counsel, what about the fact that, you know, this purportedly is a family business and they wanted to transfer it down to that particular child? Should we consider that at all?
Well, the fact that they want to transfer it to the business is, we would argue, akin to characterizing Debbie as a key employee, right? It's no different than being a key employee in effect, right? I mean, in the case that we cited, which is Barry versus Son versus Instinct Production, that was the plane crash involving the R&B singer Aaliyah. And the claim in that one was that they alleged that Aaliyah was in effect an asset of the corporation. They further alleged that Aaliyah had a long, close, and trusting relationship with the owners of that particular company. And the court nevertheless dismissed it as being nothing less than a claim akin to a familiar or a fiduciary relationship, and they didn't allow that claim to be able to go forward, right? Another case that I found in my research, we didn't cite to it, but it's the In Re September 11th litigation, that's 760 F sub 2nd 433. That was a claim by Cantor Fitzgerald. If you recall, Cantor Fitzgerald lost about 658 employees of their 1,000 employees. That included officers and employees. And they made a claim against American Airlines, also alleging to the loss relating to the business. We would say that that type of loss is akin to the loss of Debbie being able to take over the business. And by the way, I want to point out that she would never have taken over the business by herself. The intent was always that Robert, who was the son of Robert and Arlene, would take over the technical aspects of the business. Arlene was going to be running the back office, the profit and loss statements, the contracts, things of that nature. So it was never a situation where Debbie was going to be able to take over the business 100% on her own.
Thank you, Mr. Lowe. For the respondent. For the Clars.
You're muted.
Hi, I'm sorry. Can you hear me now?
I can.
Thank you. May I please the court? I'm sorry, Your Honor. Your Honors, I was muted.
It's okay.
I just want to raise a couple of issues that were in the plaintiff's in the appellant's reply brief. And one of them is that the claims regarding Deborah's convalescence was raised for the first time on appeal. And that just was not the case because the lower court required us to submit supplemental briefs, which are cited to in the decision. And there's information in those supplemental briefs, and counsel for appellants didn't want to include those because they were in the form of memorandums of law. But everything that was discussed and raised on appeal was raised in the lower court. Also, with respect to the issue of employer-employee relationship, which your honors were inquiring of respondent, it is not just an employer-employee relationship. There has been deposition testimony, and there has been evidence showing that Deborah was predisposed to support her parents from the monies that she would get from the business, and that would be a way for them to be able to be supported as they grew older in age.
But if
I
the
don't
business,
understand how. Go ahead. Go ahead, Jen.
no, I'm just wondering if the business was, if there were other children still available to take over the business, presumably they would still be able to be supported.
Well, the deposition testimony of Herbert Clark had testified that Deborah was his right-hand man or right-hand person, and that she was the only one that was working in the business at the time, and that Robert was more of the technical part, the HVAC part of it. But as far as running the business, that Deborah was the office part of the business.
Judge Gessmer, you had a question. Otherwise, I have one.
Just following up on what counsel you just said, it seems to me that what you're arguing there is really that she was like a key person. And we've held repeatedly that in that circumstance, the employer does not have a cause of action in a situation like this. So what support do you have for your clients having a right to claim compensation under these circumstances? What?
Because the difference is that in
specifically, what case law do you have that supports your claim?
So the case law is D'Onofrio versus Montalbano, 240 82nd 617, Lang versus Buju, 245 82nd 1000, and Higgins versus State, 192 82nd 821, and that where
Counsel, this is Justice Moulton. Aren't all those cases distinguishable because there the child did things like in D'Onofrio, provided for the younger sibling and contributed to the household by working outside the house, and similarly in Long, didn't the decedent provide money to his parents? And in Higgins, he worked for the family business, yes, but for no compensation. Aren't those all distinguishable cases?
Well, they're not. They are distinguishable in those respects, but they're not distinguishable because the testimony was that the monies that were going from the family business would be transferred or would be used to support the parents as they grew up in age, and they were at the retirement age. And that was the whole reason why Deborah was going to take over the business, because they could no longer work in the business. And the plan was.
I'm sorry to interrupt you, but to, I think all of the justices' questions that were asked so far, and I think as Justice Pitt or Gessmer pointed out, there was another child here, and regardless of whether she was going to be the manager or not, the money would have been able to go back to supporting them, which was, I think, your main point, is that the daughter was going to be able to support the parents, using money from the business. I don't understand why the other child wouldn't be able to do this. The co-owner, the child who was expected to be the co-owner. What does that have to do with that?
He was
and here you haven't provided the cases, as Justice Moulton indicated, the ones you've provided are distinguishable on that.
Well, there is the case law where those were the cases where the children were predisposed to provide and support for the parents, where that was the case with Deborah, where she was predisposed to support the parents from the monies from the family business. And Robert, the testimony with respect to Robert was that he was the HVAC person. He wasn't the person that would run the business and get the contracts and do everything in relation to the business.
Okay, thank you. Any other questions from the panel? Thank you.
And can I just add one last thing, if I may?
Yes.
Okay. Also, the other issue in the case, there are other issues in the case, and I just want the court to be aware that the discovery is still ongoing with respect to this case. They're taking the plaintiff's deposition in next week. We haven't done the defendant's depositions yet. There is discovery that was exchanged before this motion, supplemental bills of particulars that aren't part of this record. And therefore, that's what the argument with respect, and expert disclosures haven't been exchanged as well. And that is the reason why we feel that the motion's premature and that the defendant.
Thank you. I think we have your point. Thank you.
Thank you.
Mr. Lowe?
Yeah, thank you, Judge. So what we wanted to just emphasize is that the claim for these particular loss of services damages all arise from the operation of the business itself, right? We don't have a situation where the FedEx truck hit a building where the business was located. These are all economic in nature. And in those types of situations where the claim is for a loss of a key employee who's unable to perform due to the alleged negligence of a defendant, the court has always been very clear that those types of damages are not recoverable. We recognize that the claim is technically from both Herbert and Arlene Clark, but they're in and of itself the same as the business. There's no distinguishing between the two. Before the accident, they were working 3 days a week in the business. After the accident, they were working full time. And again, just to reiterate, one company was an S corporation, the other one's a C corporation. Ownership was solely with the father, with 10% going to Robert, the son, on the HVAC business. While Debbie has been out, they've hired another daughter, Stephanie, to do some of the work that Debbie has been done. So in our minds, this particular loss of service claim is not permissible under New York state law, and we thank the court for its time. We appreciate it.
Thank you. Thank you both.
Thank you, Your Honors.
Yep, you're welcome. VP Children.
Good afternoon, and may it please the court.
Sorry, just a moment, please. And we're starting with Shelly Rodriguez, is that right? The attorney.
Yes, Your Honor.
Right, okay.
Yes.
All right, go ahead.
Good afternoon, and may it please the court. Amanda Weingarten from Paul Weiss for appellant mother Shelly R. Shelly did not abuse her son. The moment that she discovered that Jacob was not responding to treatment for what she thought was an asthma attack, she rushed him to the hospital and in doing so saved his life. Like Shelly, the doctors initially thought that Jacob was suffering from an asthma attack, and based on their physical examination of Jacob, none of them suspected abuse. After several hours, they discovered a small tear in Jacob's esophagus, an injury that all three experts in this case agree is very rarely caused by abuse, and that has several other non-abusive causes. It was ACS's burden to demonstrate that the injury was of the type that does not ordinarily occur but for abuse.
Well, counsel, what about the rib fractures, which were found to be old in nature and requiring a certain amount of force to create?
Yes, Your Honor. So Jacob sustained hairline rib fractures, but there are things about these fractures that make them unique. First, no expert testified that these are the types of rib fractures that are ordinarily caused by abuse. And that's because they were hairline, meaning they were not full fractures, and they were also on the anterior region of Jacob's rib cage. And as Dr. Levin Brown testified, when you see abuse causing rib fractures, you typically see a full fracture and in the posterior or lateral sides of the ribs. The uncontested evidence in this case, Your Honor, demonstrated that Jacob was a highly active and mobile child. He was constantly throwing himself off of the couches like Spider-Man. He was getting into physical altercations with his
Counsel,
older
I'm sorry,
brother.
this Justice Moulton, how long was the child hospitalized?
Over a month, Your Honor. And
And-
during that entire
He had a
episode,
swollen neck as well, and he had to be intubated, correct?
yes, Your Honor.
He was also had scars and bruising on his feet, correct?
He had bruises on his feet, Your Honor.
And,
But
and
all
also
those,
on his body. So, you know, the court below referred to a constellation of injuries. Doesn't that give rise at least to an inference of abuse?
well, Your Honor, there was no expert willing to testify in this case that any of Jacob's injuries were the type of injuries that that don't ordinarily occur absent abuse. And even Dr. Gordon, ACS's expert, testified that she only reached a fallback default diagnosis of a suspicion for child abuse because she couldn't determine where these injuries came from or why they occurred.
But
And
she
if
did
they
reach
would
that
have
conclusion,
heard-
counsel, she did reach that conclusion though, didn't she? And the trial court was entitled to give greater credibility to her testimony than to the opposing expert. Isn't that right? Why shouldn't we defer to that credibility finding?
Well, to be clear, Dr. Gordon didn't testify that this was child abuse. She testified that she was concerned for child abuse. And the family court didn't even take that, she didn't adopt Dr. Gordon's constellation theory at all. She actually rejected that and came up with her own independent constellation of injuries. And in
Counsel,
doing so,
If I
she,
could ask, this is Justice Rodriguez. Dr. Levin Brown himself says that more force is needed to fracture a child's ribs than usual daily activities other than hard playing, falling, and interacting with friends, right? So doesn't that lead also to the conclusion that it could have been abuse?
well, Dr. Levin Brown testified that these are the types of rib fractures that actually don't occur in abusive situations. So, but whether or not an injury can be caused by abuse and whether ACS has proven abuse are entirely different things. And on this record, where you have all three experts testifying, including ACS's two experts, that running and jumping off of couches and falling onto hard surfaces, that these are the types of activities that can cause these precise rib fractures, on that record, there cannot be a prima facie case of abuse as to the ribs, let alone a finding of abuse, because ACS just simply couldn't meet its burden.
This is Justice Gesmer. Wasn't it also an important factor in the court's analysis that these kinds of fractures would have caused great pain for the child, and that it was difficult to understand how the mother didn't notice that the child was in pain and had not thought about trying to figure out why that was or why he was in pain. And it seems to me that's a very powerful finding. Why should we disregard that?
Well, the backdrop of this case, Your Honor, is that Shelly rushed Jacob to the hospital the moment that she discovered that he was wheezing. And that wasn't the first time she had done that. So you're starting off with a mother who does take her child to the hospital when she recognizes injury.
Excuse me, counsel, but that doesn't account for the fact that she did not claim to have been aware that he was in pain from these fractures.
Dr. Levin Brown addressed that, Your Honor, and said that when you have a hairline fracture in a child, it's very common in his experience that the child doesn't exhibit the type of pain that would cause a caretaker to rush them to the hospital. And when Jacob was in the hospital, he was evaluated for over 10 hours by doctors and nurses and staff, and no doctor or nurse or staff indicated any suspicion for abuse. There was no indication of anything broken until he underwent radiological testing. So, that Shelly could not discover hairline fractures in a child does not mean that these were abusive injuries when the doctors themselves could not have identified.
Counsel, are you comparing apples to apples? Because at the time that he was in the hospital and the doctors didn't know that he had these hairline fractures, that's because they were healing at that point, weren't they? They weren't fresh fractures.
Yes, Your Honor, they were healing fractures, but then, you could also look at the fact that Jacob sustained a wrist fracture while under the care of New York Presbyterian, and the doctors didn't discover that injury until 10 days later.
Right, but he was intubated also.
There are 16 instances in the record between July 5th and July 15th when the injury was sustained and discovered, where Jacob was alert, he was awake, he was aroused to stimulation, and he didn't express any pain in those instances. So yes, at times over the course of his hospitalization, he was incubated. But during the time where he suffered a wrist injury under the doctor's care, he was awake and didn't complain of any pain. So it's unremarkable, as Dr. Levin-Brown testified, and as the third department has held, as this court has held in Amir L in 2013, that, children who sustain hairline rib fractures don't necessarily complain of that type of pain to the degree that would cause a caretaker to rush them to the hospital. Here you have
counsel, just sorry if I missed this, but in the constellation of injuries, what about, I know that question was addressed already, but what about all of the various, injuries that taken together suggest the preponderance of evidence? I think you've been mentioning and discussing the rib fracture or hairline fracture. What about the compression that is not due to scoliosis, as there was no evidence of scoliosis? Or the black and blues that that the parent presumably didn't see then or didn't think anything of?
Well, Your Honor, the family court, to address your question about the vertebral compression, the family court explicitly found that was not an injury at all. And it found that that ACS did not create a prima facie case as to that injury. So we can't include that into this constellation. And as I've mentioned, the wrist injury cannot be included because it was definitively not caused by abuse. So then you're left with the esophageal perforation and the rib fractures and assorted bruising, in which some doctors didn't even notice bruising. But even assuming that there are bruising, with the esophageal perforation, which is the main injury, the most severe injury, the injury that caused his hospitalization, all three experts testified that injury is very rarely caused by abuse. And
yeah, I heard you discuss that before. Okay, are there any further questions? Thank you.
Thank you, Your Honors.
Counsel for Mr. Polanco.
Yes, Your Honor. Good afternoon, Your Honors. My name is, if it may please the court, my name is John Ironman. I'm the attorney for appellant Erickson Polanco. First, I'd like to state that I do adopt the legal arguments that were made by appellant Shelly R. I don't want to be redundant and regurgitate what already was said by counsel. Just a few points that I'd like to make.
Counsel, I have a question for you.
Sure.
With regard to your client who chose not to testify, isn't it correct that the court could draw an adverse inference against him from his choosing not to testify in this kind of matter?
The court certainly can do that. However, my client, the appellant, did put on a case. His case consisted of.
I'm aware of that. I'm talking about his failure to testify.
The court certainly can do that. However, again, the evidence, certainly a negative inference. It depends on the degree of the negative inference. I don't think that really has much of an impact, considering the fact that he did have a compelling expert witness testify on his behalf. May I continue? Or
sure, if you have anything else.
Oh yes, I only have 2 minutes. So one of the elements of res ipsa is the fact that the petitioner has the burden of showing that the child was in the care of the caretaker or the respondent at the time that the injuries occurred. ACS did not prove by a preponderance of the evidence that Jacob was in the exclusive care or in the care of my client at the specific time that these injuries occurred. The dates and time frames of these injuries, it was from 2 days to a week to 10 days to 50 days. It was not clear what time frame we were dealing with and whether my client, in fact, the child was in the care of my client during any of those particular time frames. Next, I'd like to also point out that, of course, these cases, a large part of the cases come down to expert testimony, expert versus expert, battle of the experts. In this case, Mr. Polanco's expert, Dr. Levin-Brown, had 50 years of experience as a medical doctor, and most significantly, Dr. Levin-Brown was an expert who was the only expert qualified as an expert in radiology and pediatric radiology. Both of ACS's experts both relied on a radiologist or other radiologists to read and interpret the radiological films of Jacob's injuries in order to render their expert opinion. Dr. Levin Brown, as an expert in radiology and pediatric radiology, personally reviewed and interpreted each of the radiological films of Jacob injuries and came to his determination based upon his.
Counsel, this is
Yes.
Justice Gesmer. It seems to me very clear that the trial judge did not credit your expert's testimony as highly as she credited the testimony of Dr. Gordon. Why shouldn't we defer to her finding with regard to credibility, since she had the opportunity to observe the witnesses?
Well, there's a few things, Your Honor. In the court's decision, in quotes, the court does make a comment in her decision saying the court credits Dr. Levin Brown's radiological findings. So she credits the doctor's radiological findings and also must have credited Dr. Levin Brown's findings as to the fact that this child did not have a compressed spine or compressed vertebrae. So I don't know if the court is, picking and choosing where to accept credibility, but also I think it also goes to the weight of the evidence. The experts for ACS, specifically, I think Dr. Salvador and even Dr. Gordon on occasion indicated that this was, to render an opinion was beyond there, and it came up a few times in the record. Dr. Salvador testified that more than once it was beyond
Counsel, let's wrap it up. You've had more than that time.
I'm sorry.
So
That was quickly.
Just
let me finish my sentence, please. Dr. Salvador testified that more than once that it was beyond her expertise to opine on the etiology of any of these injuries that were sustained by the child. And Dr. Gordon said something similar, that it was beyond her expertise to opine whether these fractures were caused by abuse alone. Thank you.
Thank you. Administration for Children's Services now.
Good afternoon. Assistant Corporation Counsel Deborah Wassell on behalf of Respondent ACS. The family court applied decades of well-settled precedent in finding that the subject child here had been abused. First, it found that ACS had met its prima facie burden to prove that the child suffered injuries that would not have occurred but for the parents' acts or omissions. Second, after the parents offered explanations for the children's broken ribs and perforated esophagus, the family court assessed this as it would any other record evidence, and finding that they did not adequately explain the child's injuries, rejected them. Finally, viewing the record as a whole, the family court found that the evidence here proved abuse. The child presented at the hospital with multiple injuries, including 2 sets of broken ribs that were undisputedly caused at different times and were both in stages of healing. He had a perforated esophagus leading to fluid and air around his heart and lungs, a life-threatening condition from which he could have died had he not received medical intervention. Because the record as a whole proved abuse, this court should affirm the findings below. I just want to address a few comments that my adversaries made during their presentations. Both of ACS's experts did testify that these were the injuries were the type to be caused by abuse. Dr. Gordon testified that these were the result of non-accidental trauma and explained that trauma is a specific injury caused by external force on the child. It's not in dispute that the rib fractures were anything but caused at 2 different times, and the fact that the child presented with this constellation of injuries, to adopt the language used by the court, renders it highly unlikely that any of these injuries were caused by anything other than abuse. If the court has any questions, I'm happy to answer them.
Anything else from the panel? Okay, thank you.
Thank you.
For the children? Attorney for the children? Is the attorney for either of the children here? Okay. We're going to move. Okay, we'll move back to counsel for Shelly Rodriguez.
Thank you, Your Honor. I just want to clarify the record that Dr. Gordon did not testify that these injuries are the type that are likely caused by abuse. Her diagnosis was called what she called a diagnosis of exclusion of any other kind, of any other explanation. Essentially, what that boils down to is that because she didn't know how these injuries occurred, that she defaulted to there must have been abuse. But a doctor's concern for abuse is not the level that can be sustained in a court of law, where the court needs to find that ACS proved abuse. No one wants to know what caused these injuries more than Shelly, but than the mother. But she doesn't
Counsel,
know.
she offered the explanation that his 3-year-old brother may have helped cause some of these injuries on his 2-year-old sibling, the subject of this appeal. The implausibility of that explanation, is there, if one posits that it is implausible, is that, can one draw a negative inference from that explanation as being so fantastical as to fatally undermine her credibility?
No, Your Honor. And because the record was full of examples of this type of roughhousing and rough play and aggression from the older brother, and the court credited Miss Shelly and found her to be credible and found her to be forthright with all of the ACS caseworkers and the doctors. But in her view, the court put that evidence aside and ignored it and said that is just not a defense because Shelly hadn't proven causation. So by flipping the burden onto Shelly to prove causation, the family court ignored all of the evidence, credible evidence, that this is a loving and attentive mother who has a safe home for her children.
Any further questions?
Your Honor, if I just may, in closing, say that the Court of Appeals has explained that the res ipsa loquitur doctrine in Article 10, it protects children from abusive parents, but it also simultaneously protects innocent parents from findings of abuse. The injuries here did not speak for themselves as abuse as is required under the doctrine, and we would ask that this court vacate the findings of abuse and return the children to their mother. Thank you.
Thank you. Mr. Ironman for Mr. Polanco.
Your Honor, I have, unless the court has specific questions for me, I will waive my 1 minute. I have nothing more to add. I again adopt what Ms. Weingarten has said. It similarly applies to my client.
Okay, thank you both.
Thank you, Your Honor.
Thank you. Elberg versus Crabapple Corp. We have the attorney for the appellant is not present, so we will.
I'm here actually, Your Honor.
Oh.
I had trouble signing in. I apologize.
Yeah, counsel, you're supposed to sign in at 1:30.
I know, I signed in at 1:31 and the link was not working. And my IT department has been working on it for 45 minutes and we finally got it through. I apologize to the court though.
And to opposing counsel. Okay, so that's 5 and 1 then. And opposing counsel, you are back to 5 minutes then.
Thank you, Your Honor. Are you ready to proceed?
Yes, thank you.
Thank you, Your Honor. May it please the court, it's Stephen Younger of Foley Hoag on behalf of the appellants. This case concerns a dispute over which limited partnership agreement governs a hotel project. There are 3 separate reasons why the court below should have ruled in our client's favor.
Counsel, can I just,
yeah.
I don't mean to interrupt you, but I just want to just ask this question
Sure.
initially. As to defendant Pusner, had she testified or indicated in some way that the November agreement is the one that applied and then later tried to change that to the August agreement?
Well, actually, it was just some confusion, Your Honor, that often happens. That's at 1876 of the record. The very next page, 1877, she makes clear that it was confusion in the testimony. But I think, Your Honor, the most important point is that every single person who's a party to this case signed a merger agreement. And that merger agreement represented that it was the original agreements that controlled, and there were over $35 million in proceeds paid as a result of that. And now, having produced these funds and sold off the hotel properties, it's actually the other side that wants to get those proceeds. They want to get the proceeds.
Let me just ask this next question then about that August agreement. Wasn't there a capital event that wasn't met? There were the $6 million that was supposed to be raised wasn't raised, and then the agreement, it expired. It didn't continue. That's why there was a second agreement in November.
That's sort of half right, Your Honor. The original agreement didn't expire. It couldn't expire because to expire, you had to return the money. And by the way, if there's any issue about this, it's a question of fact. But it's undisputed that the money was never returned. That's number one. It's also undisputed that the agreement itself requires that there be a signed amendment, which never happened because this thing was never really signed in the regular course. But I think even more important, if you look at the Uniform Limited Partnership Act, you need a vote of the limited partnership. And the EB5 investors never voted. But, at the very least, those are all questions of fact. But I think most critical is the merger agreement, because $35 million came in. It paid off the debt on these properties. And it ended up being a great event, or as a good event as you could for everybody. And Rubin wants to take advantage of that, but he doesn't want to be bound by the terms of that agreement, which say the August agreement controls. Now, there's a second reason why. I'm sorry, Your Honor.
I'm just going to ask the question. This is Justice Rodriguez. My understanding is that Peter Jensen, Catherine Holmes, and Ms. Pusner all at one point stated that the November agreement was the controlling agreement. In fact, Ms. Holmes said that she drafted both agreements and that the November agreement was intended to be the controlling one. What should we make of that information?
First of all, it's not correct what Mr. Jensen testified. Mr. Jensen couldn't even remember having seen this agreement. And by the way, it wasn't even in anybody's files, right? So, but more importantly, and I'd just like you to look at it, page 1714 of the record, that's Mr. Jensen's signature on the merger agreement. So despite this testimony about, this litigation-induced stuff that went on, at the end of the day, Mr. Jensen signed a binding agreement which produced $35 million worth of proceeds. And that agreement represented that it was the August agreements that controlled. And I don't see any way around that, because you could have this kind of back and forth. To be clear, Jensen never signed this in the regular course. It's like years later after he'd already rejected the deal. And so, that's yet another reason why, as a matter of law, my client should have won down below. Because it's just basic contract law that if I make an offer to you and you reject it, then that offer doesn't exist. But it's even more than that, because if you look at page R404 of the record, his lawyer told the other side that they should pay the money back. How can you say that this November agreement went into effect when Mr. Jensen was asking for the money back from the August agreement? And it never happened. So I just think that there are a host of reasons why, as a matter of law, my client should have won down below. But even if you get past that, there are just so many factual issues here. First, whether Jensen even signed it. And I think Your Honor noted that there's testimony that they pull out of context. Ms. Holmes, the lawyer, she wasn't a party to the contract, so you have to ask the parties whether they signed it, right? Second, the point that Your Honor made, Justice Pitt, was this the original agreement or the later agreement? These are all questions of fact, not things that you can rule on in summary judgment. But I think even more importantly, if you look at page 2412 of the record in 1714, Rubin himself and his father swore to a bank that his father owned no interest, his father owned the whole thing. And a bank made a binding loan commitment. How can you tell a bank that your father owns the entire interest and then come along and tell a court that it's yours? It's just, and by the way, Justice Ramos found that either Rubin was not telling the truth or he sort of wouldn't know the truth if he fell upon it. Just that alone, the credibility here would have required a trial. But we think there are several reasons why.
But didn't we already find otherwise with regard to Justice Ramos's decision? Okay, it's true, he called himself a sole managing member, but we said he wasn't a sole managing member, but He was a 40% minority member.
Your Honor, I think that's pure dicta. The issue in the prior crabapple appeal was whether you could remove Rubin as a matter of law or you needed a hearing. The sole ruling that this court made, and Your Honor was there, so you would know
That's
better
why
than
I'm
me.
waiting for you to tell me what
As
we
was Judge-
decided when I was on the case, but go
I
ahead.
know, as was Judge Gesmer. So I think if you look at it, he was raising a red herring. He was saying, well, you couldn't remove me because I was a member. And it was sort of like pointing out that that's an irrelevancy. How can you make a finding of fact when the sole holding was you need a trial, right? And more importantly, that issue was never litigated in the court below. There was never any of the kind of back and forth of putting on proof. It was simply an aside that he raised as kind of a red herring to say, you can't do this. And by the way, as this court held 2 weeks ago, that case had been settled. So it shouldn't be binding anyway. But I think more importantly, if you look at what the court held, it was simply that there was a question of fact that needed a hearing. How could in one hand can the court say there's a question of fact needing a hearing, at the same time say we decided for all time a fact? It just would be wholly inconsistent. And I think it was just trying to reject something which is something of a red herring. But I think.
Thank you, counsel. I've allowed you extra time, so we should move to opposing counsel.
I apologize.
Unless the
Thank
panel
you.
has any questions? Does the panel have further questions? Okay, thank you.
Thank you, Your Honor. May it please the court, Brian McCarthy for the plaintiff respondent, Ruben Elberg. Your Honors, Ms. Pesner did testify in open court that the November partnership agreements were the last signed and ratified contracts for the partnership. More importantly, when a foreclosure action was brought against the properties that were part of this limited partnership, it was Ms. Pesner's attorneys who submitted those very November partnership agreements and claimed that they were controlling in order to provide standing to answer the foreclosure lawsuit. With regards to Mr. Jensen, his testimony is clear. At his deposition, counsel for the defendant appellant provided him with a copy of the partnership agreement that was not signed by him. His testimony was, I am surprised that the copy you have doesn't have my signature. There was absolutely a second agreement which added a Class D limited partner, and I remember specifically signing it. I don't know if it's this one that you have in front of me, but it had, because it doesn't have my signature, but I know there was one I signed in the offices of the Elbergs. You cannot premise an appeal on the fact that Mr. Jensen did not sign the agreement when he testified he did and he recognized it. Mr. Jensen, more importantly—
Counsel, can you address the merger agreement?
Yes, Your Honor. The merger agreement was entered into after the first Justice Ramos order that found that Ruben was a member, but he was not the managing member. Mr. Elberg filed a written dissent to that agreement at record 1717 to 1718, where he specifically said, I am the Class D partner. You do not have my authority to move forward with this merger agreement. This merger agreement was done in August for one purpose, because it was done to steal from my client tens of millions of dollars that belonged to him. Every single one of the partners, and it must be remembered that the money here was raised by getting EB-5 visa applications. The record is clear, both the Class A and Class B partners and the EB-5 investors who were outside of the partnership agreement and represented by Mr. Zhao submitted to USCIS applications where they swore that the controlling partnership agreement was the November agreement. The record is wholly devoid of a single application citing the August agreement as being controlling. There is no material question of fact. The August agreements did expire. The money was required to be raised by September 30th. It was not raised. Ms. Holmes, the attorney draftsperson—
Well, counsel, I'm sorry if you mentioned this, but let me just clarify. Does it matter that the money from that August agreement was not returned? Was it required to be returned?
It was not required to be returned because Ms. Holmes, who was the attorney draftsperson, said the partners agreed this was not an amendment. We were starting a new partnership agreement. There was a fundamental failure. We were to raise for one of the hotels $1.5 million, for the second hotel $6 million. We failed to raise the money. We needed a new partnership agreement. That partnership agreement altered the definition of capital event. It added property into the partnership agreement, and it also provided the means by which in this partnership agreement, the November partnership agreement, the parties could agree to extend the investment date in order to move forward. The August
Wasn't that then an amendment to the August agreement?
Your Honor, it was not an amendment because there was no provision in the August agreement if there was a failure to raise the money for it to continue. There was no way to amend that agreement. The parties came forward, went back to the same attorney draftsperson and had her.
Yes, I understand. In the November agreement, you were able to move the date for raising the money.
Yes, Your Honor.
Mm-hmm.
And one of the fundamental issues here also is with regards to the merger agreement. If you read the definition of capital event under the August agreement, it requires a sale of a subsidiary. That never occurred. The November agreement instead changes that definition to a sale of all of the assets or substantially all of the assets of a partner. That is in fact what occurred. There was not even a capital event under the August agreement. There was a capital event under the November agreements.
Any other questions? Okay, I think we're back to Mr. Younger.
Thank you, Your Honor. It sort of, to me, sounds like a closing argument to a jury. You know, for every fact that you heard, there's an opposing fact. But more importantly, you didn't hear him address the merger agreement because even though his client protested, Mr. Jensen approved it, every EB5 investor approved it, and $35 million went to pay off the debt and sold the properties. How can that not be binding? So I think as a matter of law, you also didn't hear a response to why this wasn't a counteroffer that was rejected. You know, every one of the points that are a matter of law have not been rejected, have not been answered. And I think that Your Honor should rule in our favor, and I appreciate your time.
Thank you. Thank you both. Landon C. versus Thread Council.
Good afternoon, Your Honors.
Good afternoon. You may begin.
Thank you, Your Honor. Judd Grossman on behalf of Appellant. May it please the court. The lower court erred in dismissing plaintiff's fraudulent inducement claim as duplicative of its breach of contract claim, an argument that the other side never raised below, and therefore the parties never briefed. In reaching that conclusion, the lower court misconstrued the facts actually pleaded, and so I'd like to begin by very briefly highlighting certain key facts supporting the fraudulent inducement claim. During the first wave of the COVID-19 pandemic, defendants, a startup fashion brand, sought to secure a tremendously lucrative opportunity from the state to provide tens of millions.
The contract with between Landon C. and Thread Council was for the level 1, the class 1 gowns, and that's what Landon C. produced, isn't it?
Your Honor, the contracts between plaintiff and defendants did not specify anything about the fabric. All that it said is that defendants.
No, it didn't say the fabric. It said, at the time, it said, I think it said level 1 gowns, and it said the amount of gowns and the price.
That's not correct, Your Honor. And it's exhibits 5 to 9 in the record at 42 to 49 are the purchase orders. None of the purchase orders specify the barrier protection level. Those are statements that were made to the plaintiff by the defendants to induce the plaintiff to fabricate gowns that the defendant said were needed to fill an order from the state. All of the misrepresentations that we allege relate to statements and omissions concerning the state contract.
Right. So if any party was defrauded, it would be the state, right? They contracted for something, they got something else. Your client, their remedy is to sue under the contract for non-payment.
Well, that is certainly one remedy, and I'm not suggesting the state wasn't defrauded either. The allegations in the complaint, reasonably inferred based on the facts pleaded, suggest there was a scheme to deliver what essentially amounted to counterfeit gowns to the state. Okay, just like N95 masks were seeing rampantly counterfeited, same thing with these gowns. And defendants.
Counsel, what I don't understand is what damages do you claim for your alleged fraud claim that you wouldn't get under your contract claim?
Sure.
Why isn't that simply duplicative of the contract claim?
Well, two answers to that, Your Honor. Number one, in paragraph 52 of our amended complaint, we do allege special damages, costs including storage costs that wouldn't be available to us under a breach of contract theory. But
what does that have to do with fraud? What do those storage costs have to do with fraud and the inducement?
Sure. Plaintiff was induced to produce these gowns, being told that they were for an order from the state for the highest level barrier protection.
No, I understand that. You're saying that you had to storage fees. I'm asking what that had to do with fraud and the inducement.
Yeah, sure. I'm sorry for not more directly answering the question. The storage fees relate to the gowns that plaintiff produced after being induced into the agreement, but which weren't delivered after the state discovered that these were counterfeit gowns. And
yes, but that has nothing to do with your client. Your client produced them. That's what their responsibility was to the defendant. So the contract covers your client producing gowns for an amount of money.
No,
whether they were, the ones that are in storage were part of the amount that your client was expected to produce and did. Isn't that right?
Did produce, but was told not to deliver because the state had rejected these gowns. In the absence of a fraud, the state wouldn't have rejected the gowns. The state would have accepted what they were told would be level 3 gowns, but in fact were these counterfeit gowns made with, among other things, fabric material that they procured from a Home Depot. So all of those consequential damages flow from the fraud. But to be clear, this court's precedent, as the Second Circuit for the last 30 years has summarized, does not require different damages. That is one way to show the claims are not duplicative, but we cite any number of cases, including the Merrill Lynch case, including Judge Rakoff's recent decision in Wild Bunch in footnote 5, where the court makes very clear you can satisfy the fraud claim as not being duplicative if you can prove any one of the 3 elements, damages just being one. The other,
Counsel, I have another question.
Sure.
This is Justice Gesmer. So your client contracted to manufacture these gowns pursuant to laws of motion's contract with the state. Did your client do any due diligence, like asking to see the contract with the state?
Well,
I found that I didn't see any evidence that it had, and I found that sort of surprising. It seems to me that one would have wanted to do that minimal amount of due diligence.
Well, two answers to the question. The first is, and this is in the record in the state complaint, there's a confidentiality provision that would have precluded laws of motion from sharing it, number one. But number two, to be very clear, defendants do not challenge and for purposes of the motion conceded reasonable reliance, materiality, and damages. So while that may be a question of fact, it wasn't one raised below, and it's certainly not capable of resolution at the pleading stage. But going back to the point of damages being the same, I think this court's decision in MBIA makes very clear that there can be a cause of action for fraud in the inducement while at the same time a contract claim.
Counsel, you're right. We have cases like that. Do you want to spend some time talking about Ms. Beege and did you sufficiently articulate, with the degree necessary that the fraud get committed allegedly by her?
Sure, thank you, Your Honors. And I think just as in line with the Court of Appeals decisions in Pluteman and Politensky, we've pleaded facts that Ms. Beege, in essentially what was a 1 or 2 man operation, was actively involved at every stage of the negotiations and overseeing the sourcing of the fabric that was the subject of these agreements. And we plead very clearly in paragraph 30 to 31, 34 to 38. And again, for purposes of this motion, they don't dispute that Ms. Beege misrepresented to plaintiff that the state contract, not the plaintiff's contract, the state contract called for gowns with a low-level barrier protection when in fact the state had ordered the highest level 3 gowns. Also, Ms. Beege lied to plaintiffs that the defendants already had sourced the necessary fabric for the state contract, when in reality, not only hadn't they sourced it, they couldn't source it. And we plead in detail the efforts and lengths they went to get any fabric to use, including from the Home Depot. So Ms. Beege, coupled with those specific allegations and the court's precedent in Pluteman, that where she's involved as actively as she was, that more than supports a reasonable inference that she knew of and participated in the fraud. to be very clear, we're not seeking to hold her liable for fraud simply because she was an officer. It's the fact that as an officer, as active as she was, she directly made the misstatements to the plaintiff, inducing the plaintiff into those contracts. Your Honor, the other point.
Counsel, we've gone over your time. Do we
Thank
have
you.
any other questions from the panel? Thank you. Counsel for Thread Counsel.
Thank you, Your Honors. May it please the court. The decision below, Land & Sea is trying to reverse a well-reasoned trial court opinion that follows well-settled New York law. In essence, this is a breach of contract case. It started as a breach of contract case and it should remain.
Counsel, would you mind picking up the thread about Ms. Beege, since that's who we were just talking about? And she was not a signatory to the contract, or she was not bound by the contract anyway. So was there sufficient allegations pursuant to CPR 3016 concerning her?
No, as the trial court specifically found, she may have acted negligently in variously negotiating allegedly different product specifications with New York State and the plaintiff, but there is nothing in the allegations of the amended complaint that rises to the level of fraud. That's in the record, page 5, and that's a reason why fraud is inappropriate, because scienter has not been pled adequately against either Ms. Beege.
Well, counsel, can I just ask? So if she negotiates with the state to deliver whatever it was, class 2 level 3 guns, and then she negotiates with plaintiff to deliver gowns that are class 1 non-surgical, and they're going to use the gowns from plaintiff to deliver to the state, then what else is it other than fraud?
So I'm glad you asked, and I would like to clear up discussion previously about the allegations in plaintiff's complaint, and frankly, the allegations that could be supported by any readings of the facts. So to go through this very carefully and to answer Your Honor's question, which is a very good question. First amended complaint, paragraph 18 states, although defendants had absolutely no experience producing personal protective equipment, which by the way is not true, in late March 2020, during the height of the COVID pandemic, defendants responded to the state's RFP for products and services to help fight COVID. Paragraph 19 does not indicate a date when this happened, but states defendants submitted a written proposal to the state representing that they had large amounts of gowns available. At first, defendants stated that they had 1,000 gowns in New York ready to ship, with the promise of being able to produce 10,000 more per week in our New York-based factories in the next 2 weeks. Laws of Motion's Land & Sea's opening brief clarifies an important point with regard to this allegation, and this is at page 2 of the opening brief. Laws of Motion's first offer to the state was for non-surgical gowns, which is another way of saying class 1. Now, First amended complaint, paragraph 31, when the defendants contacted Land & Sea on April 1, they stated, pursuant to the status of the discussions with the state at that time, we, quote, we need class 1 non-surgical gowns with elastic wrists. First amended complaint 20, the state told the defendants that it needed tens of billions of gowns. And once again, Land & Sea's opening brief clarifies correctly on page 7, the state then communicated to Laws of Motion that it needed level 3 surgical gowns at that time. Then the first amended complaint at paragraphs 25 and 28 says, April 2nd, the next day, that's when Laws of Motion submitted its proposal to the state to provide level 3 surgical gowns, which the state accepted the next day. The first purchase orders, the first 2 purchase orders of 5 that Laws of Motion then submitted to Land & Sea took place 15 days later on April 18. And they specifically provide, this purchase order is from Thread Counsel Inc., and this is the very first line of the purchase order, for Land & Sea confirming that Laws of Motion is ordering surgical gown production capacity. In other words, not level 1 gowns. Now, to one of the earlier questions about conducting due diligence, it would have been easy enough. I mean, the contract between Laws of Motion and the state, the purchase orders, are public record.
Can I just interrupt you before you get to that point? Was there anything else in the first purchase order that said anything about the level of the gowns?
Yes.
It only said surgical gowns after all of what you just said about how one said level 1 and then one said level 3. One would expect that there would be clarification on the first purchase order. Are you saying that all it said was surgical gowns?
No, the first purchase order also stated it twice. And surgical gowns, as Laws of Motion, as Land and Sea's brief itself concedes, surgical gowns are the level 3 and level 4 gowns. Non-surgical gowns are level 1 and level 2 gowns. That's very specifically set forth in one of the earlier sections in both Land and Sea's complaint and in its opening brief.
So you're saying the first purchase order said surgical gowns, and that should have clarified everything because it said surgical gowns.
The first line of every one of the 5 purchase orders specified that it was for surgical gowns. However, as a practical matter, that fact would have been more or less immaterial to Land and Sea because Laws of Motion was providing the fabric. Land and Sea was simply cutting and sewing. So Land and Sea was not required to procure any type of fabric or anything like that. Right. Also, the point that the materials came from somebody went to Home Depot, that's not an accurate characterization. Material was purchased from Home Depot corporate, which is where it ordinarily can be found and purchased, not somebody went into the garden aisle and picked it up.
In any case, it was not level 3 fabric.
It was level 3 fabric. It was level 3 fabric that we provided, we tested, and supplied to the state. We are in a dispute with the state as to whether it meets the standards, and we are in a dispute with Land and Sea and we're endeavoring to inspect the gowns remaining in their possession, whether any fabric was swapped out, because the fabric at issue was hard to procure if you didn't specifically have the supply chain to do it, which we did, but others didn't, particularly in Guatemala, where the in-question gowns were made. It's not uncommon for material to fall off the back of a truck at the possession of the supplier. So,
any further questions from the bench? Okay, your time is up, if you would wrap up.
Yes, ma'am. Thank you for your time, and we just urge an affirmation of the lower court's very reasonable order that follows standard New York law.
Okay. Back to you, Mr. Grossman.
Thank you, Your Honors. My friend's argument was replete with factual questions, virtually all of which are in dispute, but none of which are capable for resolution at the pleading stage. But I will point the court to paragraph 31 of the state's complaint against Laws of Motion, which of course the parties cite and this court can take judicial notice of, saying that they tested all the fabric and none of them met level 3 requirements. So there's no dispute as far as the pleadings go that these didn't meet level 3 standards. The reason this is important, and Justice Renwick, this goes to your initial question. Laws of Motion couldn't sew these gowns themselves. They needed plaintiff to do it. In paragraph 38, we allege that defendants told us that the fabric would only meet level 1 specs. That's why they lied and told us that the state contract only called for level 1, not level 3. Justice Moulton, to your point before, you're absolutely right. Ms. Beegee was not a party to these contracts. She can't be held liable. We don't seek to hold her liable as an alter ego. And therefore, as a matter of law, the claims can't be duplicative. And finally, Justice Ostrager held that at best these allegations rose to the level of negligence. Again, that fact finding is not appropriate at the pleading stage, but it's certainly not unreasonable inference for a fact finder to be able to find, based on these pleadings, that Ms. Beegee and defendant acted with knowledge that the statements they were making were false at the time they made them, because we're talking about a 1 or 2 day period here. They're making very different statements to the state at the same time they're telling us that these are level 1 gowns. Thank you.
Thank you. Thank you both. Goyard, New York versus Freeland Properties.
Yes, Your Honor. Can you hear and/or see
Yes,
me?
you may begin.
Thank you, Your Honor. May it please the court, my name is John Hannum. I represent the defendant appellants in this litigation. This action basically arises out of a claim, Building Code 3309, adjoining property work.
Counsel Scalpel was the one who was doing the shoring and everything else in this in the building. Doesn't there have to be a finding of negligence first before there can be indemnification here?
It doesn't, Your Honor, and that's under the Licata versus A.B. Green case, where actual negligence does not have to be found. In this situation, not only was Scalpel tasked under their scope of work to do the excavation, they also performed the supportive excavation, the underpinning work, the dewatering work, and actually the foundation installation. So,
but how do we know that there's negligence? How do we know that they were negligent?
plaintiffs' experts have all claimed that the damages to the adjoining property were the result of subsurface work.
But don't they say that don't they have an expert that says it could have been work that the homeowners did themselves, and that could have been it?
That goes to the damages, Your Honor, not to the liability. There was pre-existing issues with the Goyard building that the defendants claim pre-existed this construction project, but the damages alleged by Goyard in this litigation are alleged to have started in August of 2015, and that was when Scalpel was at the height of its work, performing subsurface work. They hired consultants for dewatering, they hired consultants for supportive excavation, and they hired consultants for contractor for pile driving.
Counsel,
Justice,
yes. Oh, I'm sorry.
Yes, of course.
No, I thought Justice Gessmer had a question, but perhaps not. Okay, Justice Rodriguez.
So the question that I have is, isn't there some information allegation that it's possible that the damage that was done to the building was caused by sidewalk repairs or constructions that were done after Scalpel had finished its work?
There has been allegations of that, Your Honor, and I think they're spurious. The fact that you're removing a sidewalk and reinstalling a sidewalk does not require subsurface excavation work. You're on grade. Yes.
Counsel, even though you claim that they're spurious, it seems to me that those statements by an expert raise questions of fact that are problematic here. Certainly as to whether all of the damages were caused by the negligence, of Scalpel. So calling them spurious doesn't really resolve the issue.
Well, I understand, Your Honor, and when by the time the sidewalks were being installed, and the expert really never addressed this issue, when the sidewalks were being installed, the building, the Goyard building was still there, but the adjoining property was out of the ground. Once the construction fences were removed, the building was out of the ground, the facade is up, and the sidewalks are being installed. They're not going to install sidewalks while construction is still going on because you got the sidewalk sheds and everything else for protection and construction fencing. So this sidewalk work, the reason I call it spurious is because that all took place after the 706 building was above grade and came out of the ground. So once that happens, the Goyard building is stabilized from the existing foundations of the new building, and there's no more movement. And that's proven by the optical monitors that were in place around the properties. So
anything else?
Yeah, so I guess my point was originally that the experts claim by plaintiff that all damage caused by subsurface work. Scalpel had all the subsurface work, all the consultants, all the engineers, all the experts, they performed all of this work. And during the course of the project, Goyard came over to the adjoining structure and said, I'm having damage. And Scalpel went over next door to say, okay, what damage are you sustaining? So any damage that took place from the party wall, from underpinning or excavation work, was all the result of Scalpel's work. And
But counsel, aren't you also asking us to ignore the findings by Scalpel's experts that plaintiff's own interior renovation work contributed to the damages, and that the demolition of the sidewalk, which we talked about a little bit, might have caused further damage to plaintiff's building? How can we just ignore that at this time, in this procedural posture?
Well, because the application before the court is on indemnification. Damages between the parties is a separate issue. We're asking for indemnification against Scalpel, whether it's actual indemnification or conditional, that any damage that's sustained by the plaintiff as a result of this adjoining property work.
Well, are you claiming that Scalpel's responsible for any injury to the building, regardless of whether its work had anything to do with that damage? That seems to me to reach far beyond what its indemnification clause provides for.
No, we're not asking Scalpel to be responsible for any other contractors, but there's no allegation that any other contractor caused the damage other than Scalpel.
But there is. They're saying the issue about the vibrations and maybe the owners themselves doing their interior work. So there is.
Well, the vibrations would have been the result of pile installations during the actual excavation and foundation work. Interior work, once the building and the shell is up, you're installing sheetrock, electrical, partitions, things of that nature. That's not causing vibrations to an adjoining structure. That's interior work that's not going to cause damage to an adjoining building. In this situation, any vibrations that would have taken place would have occurred during the excavation and foundation work. And the identification.
Thank you. Let's hear from, your time is up. I think we have the point. Let's hear from the counsel, opposing counsel.
Did it turn on? Sorry, hold on. Thank you. I represent Scalpel, and I think the issues brought up by Judge Gesmer and Judge Renwick are right on point. The indemnification clause at issue requires a determination of causation. And with respect to the entire situation, it is noted that the Friedland and JRM have an independent obligation to the plaintiffs with regard to monitoring vibrations and other things. With respect to the damages, it is an issue of damages. The Friedland and JRM are at this time asking for complete indemnification of any and all damages caused by the construction at 706 Madison. However,
your point is to be, yeah, go ahead.
I'm sorry. Scalpel, as the court has noted, was only there for a certain amount of time. And it's interesting to note that in their own appellant brief, the appellants are denying that any of the damages claimed by plaintiff were caused by the construction site. But if they were caused, they only could have been caused by Scalpel. However, as the court has also seen, there are opposing experts as to when and where damages were there. There's, as noted by appellant, pre-existing damage that Friedland was also supposed to document and take care of. And then when they did the walkthrough, when there was a complaint to Scalpel about the underpinning, it was determined that this looked like old pre-existing damage and not from the underpinning and or dewatering. And in addition, the plaintiff's allegations as of 2020 say continuing damages. Scalpel was only there for a certain limited amount of time. And at this time, if there needs to be a determination of causation, that does go to whether or not they're owed indemnification, in addition to the fact that they have their own independent obligations. Therefore, at this time, they may be actively negligent, independent of Scalpel's own work because of their breach of contract and their own contractual indemnifications. So in the first instance, they're not owed indemnification at this time. And in the second instance, with respect to the need for a determination of causation, because this is a property damage case, as opposed to a personal injury where you can automatically say, the plaintiff tripped over my electrical wire and things of that nature, there is no exact determination of the causation of the damages. And with respect to the vibrations that were brought up, I appreciate appellant's arguments that it's a raised building. We have an expert that says just merely because the building was already built does not necessarily mean that the sidewalks didn't cause settling or unsettling of building. I mean, it's the interior of the building too, any vibrations. And the contract between Friedland and the plaintiffs has an independent obligation to monitor these vibrations. And whether or not they violated that is, again, part and parcel of determination of causation. So at this time, we believe that the lower court was correct and that it should be determination of contractual indemnification should await a trial. Thank you.
Thank you. Back to you, Mr. Hannum.
Yes, thank you, Judge Irwin. Again, I think counsel is confusing the real properties action proceeding law 880 agreement between Friedland Properties and the adjoining property owner with regard to the actual work performed by Scalpel. Plaintiffs, the respondents' experts claim that the defendant appellants may have, and it's in their expert report, may have some independent acts of negligence, or it's possible they have some potential negligence, but they don't specify what that is. And there's been nothing in the respondents' experts' reports that have pointed to anything that the appellants have done wrong with this property. All the work alleged by the plaintiff, the damage alleged by the plaintiff, I apologize, occurred only while Scalpel was on the project and their consultants and subcontractors. That's all the damage. And the red herring of sidewalk damage when it's on grade or putting up sheetrock wall in an adjoining property is going to cause damage to an adjoining structure. No expert on the witness stand will affirm that. I just don't believe it.
Thank you, sir. We understand your point. Your time is up. Thank you very much.
Thank you. Take care.
Thank you both. Aviation distributors versus aviation.
Good afternoon. May it please the court, my name is Solomon Zabrowski, and I'm representing the appellant in this case. Basically, the judge ruled against my client because there was a criminal conviction of my client. And she used the fact of the criminal conviction as facts.
So your point is that in the last appeal, we reversed that decision. And so it's your position that that testimony can't be used here. Now there are questions of fact with regard to these issues.
Yes, Your Honor. And in fact, there was a motion for summary judgment prior to the criminal conviction in which Judge Edme denied the motion, claiming there were factual issues.
Counsel, this is Justice Moulton. The 1977 corrected deed, doesn't it have like absolutely facial problems that show that it couldn't possibly be from 1977, and that the font used was not even developed until, I don't know, sometime in the early 2000s, and the document refers to satellite dishes, which didn't exist in 1977. I mean, isn't there enough there apart from, say, we agree with you, no collateral estoppel from the criminal case, but just on the face of the document? Isn't there enough there to say that it's absolutely a fraudulent document?
I don't think so with respect to this particular property, Judge. The history of this property is very
unquiet.
Yes, that's right, Your Honor. I just think, and what we wanted from the beginning was discovery, and we wanted to examine.
Wait, Counsel, what about my point about the document itself, and that it's just kind of like on its face, not worth anything? I mean, that's the argument. So could
that's the argument, but that's the argument. But my client shouldn't be held. That shouldn't be held against my client because he was in jail at the time. He couldn't cooperate with challenging these allegations.
Can I ask you, wasn't the corrected deed filed? Wasn't the corrected deed that he created, wasn't that filed?
It was filed with the.
So then if that deed was filed, and the filed deed apparently on the notary page, it has the notary page is to another mortgage assignment document, and none of the property's principals signed it. Why? How could that be valid if that doesn't?
Well,
Doesn't
none of
that
the,
suggest right there, doesn't that undermine?
no, and the reason why it doesn't undermine is because my client hasn't had a chance to specifically deny the allegations.
Okay,
And that's the whole
Judge
point.
Gessmer has a question?
Yeah, Mr. Zabrowski, I didn't hear any response from you to Justice Moulton's question about how we could possibly consider the 1977 deed valid when it was created in a font that didn't exist in 1977. Could you explain that?
Yes, I wish I knew how you could do that, but I'm not the client. I'm not John Z, who may very well have a legitimate explanation.
Well, let me ask you this
No.
question, counsel, just in terms of the criminal conviction, which was overturned not by any weight of the evidence, but mainly because of the failure to allocate to the pro se, for him to go pro se.
Yes. Well,
has this issue already been decided then?
No, and the reason why is because every court proceeding in our legal system is that it's one side against the other side, that both parties fight it out to ultimately get to the truth of the matter. Here, Mr. Z was unarmed. We shouldn't hold anything against Mr. Z because it's not that, it's that he may very well be delusional. I don't know. I don't
We understand your point. Are there any other questions from the panel? And do you have anything else, counsel?
No, Your Honor. I think the court understands my argument.
Okay, I think, thank you.
Thank you.
We first go to Aviation 1945.
Good afternoon. May it please the court, Vincent Chirico for Aviation and 1945 and Diane Hazlitt. Justice Pitt, I think your question was particularly on point, which was even if there was a reversal of the criminal conviction on the procedural basis that Mr. Z did not get a proper mental health evaluation, that does not eradicate all of the evidence that went into the criminal trial, all of the sworn testimony, and under the Court of Appeals and this court's precedent, where a subsequent proceeding is a civil one involving a lower standard of proof, an acquittal, even an acquittal, is not proof of innocence. What's clear here is that Mr. Z.
Counsel, I don't understand your argument. How do we parse which parts of the trial are still good and which aren't? Once we reverse it, the conclusion of the end of the conviction is a nullity. The testimony may stand for what it's worth, but how can we draw any conclusions from that trial when he essentially wasn't represented?
Justice Gessmer, I agree with you completely. I was answering the question that Justice Pitt had issued with regard to the differences. However, our position is, regardless of whether collateral estoppel applies or not, the same result is warranted here. Not only, even if you set aside the evidence that was submitted in the criminal trial, you still have testimony and evidence in the summary judgment motion that indicates that the deeds were fraudulent and that nobody ever tendered any property to Mr. Z or his company Kojo.
Yeah, all of this,
how do we deal with it? I'm sorry, go ahead.
No, it's all of this ended up in a trial. There were issues of fact that led to this trial.
Yes, Your Honor, but even if you take that aside, on the summary judgment motion, in addition to the testimony that was given to in the criminal trial, we also submitted the affidavits of Diane Hazlitt, the Lois Waitiki affidavit, which established prima facie not only the chain of title in the land, but that the people who signed the deed on the purchase side and the Kojo side had no authority to do that, and that the administrator of the estate that transferred the property could only transfer what property they owned at the time. So we set the chain of title and we set the history, even apart from from the criminal trial testimony. The key here is that in opposition to that prima facie finding, that Mr. Z and Kojo did not contest any of the evidence, whether it was the evidence in the criminal trial or the evidence that's submitted in summary judgment. So there are two arguments that Mr. Z makes. Number one is that he gets another chance to prove that the deeds were not fraudulent, but in opposition to summary judgment, he did not submit any evidence even indicating a potential triable issue fact on that score. There's no substantive argument made whatsoever on summary judgment.
Counsel, the problem is that the motion court relied on collateral estoppel. The motion court didn't analyze, as I understood it, exactly what documents were in front of it. It simply said there was still a collateral estoppel effect of the criminal trial, and I'm having difficulty seeing why that can be the case once we reversed it.
Well, our contention here, Justice Gesmer, is even if the trial court had not limited its reasoning on collateral estoppel grounds, we were still entitled to summary judgment because of the substantive evidence provided prima facie and the lack of tribal issues.
Okay, so you're asking us to search the record and find summary judgment. What are you asking us to rely on specifically in the record in order to accomplish that end?
The affidavit by Diane Hazlitt, which indicates that Aviation had the land in 1976, owned the premises, never tendered the premises to anyone. The affidavit of Lois Watiki, the administrator of the estate of Marion Miller, who owned the property before, that indicated that she only transferred what the building subject to the leasehold, and to the extent that we seem to be going around on the question whether this was an acquittal or a reversal on procedural grounds, I do quote Reed versus State and People versus Matthews that holds, again, whether the subsequent proceeding is a civil one, it involves a lower standard beyond the reasonable doubt. And I'd like to point out that even Justice Peter Tom, although he dissented from the appeal, he even said that procedural error aside, which was the reason for the reversal, the judgment otherwise was sound and should have been affirmed. So on that issue, we believe that the lower court was right in result, if not necessarily on reasoning. Now, we're also appealing from the subsequent order that granted re-argument to.
I'll give you 30 seconds because your time is up.
Okay. So there's two problems with the re-argument order. Number one, procedurally, community didn't raise either the leasehold issue or the statute of frauds argument in its underlying motion, or addressed it for the first time on re-argument. To the extent the community was seeking renewal and not re-argument, they didn't set forth why they didn't address these issues in the original motion. In the community actually says that all we submitted was verbal evidence. We didn't. We submitted documentary evidence of the memorandum of lease and of the deed to community that specifically, explicitly, on its face at page 1228 of the respondent's appendix indicates to the extent owned by grantor and subject to the 99 years lease held by El Pridian. We absolutely covered the issue, and we believe that the trial court was incorrect in determining that Aviation and Hazlitt did not seek that argument in its original motion.
Okay, thank you.
Thank you.
Now from community.
Thank you. May it please the court. Just very briefly, we do join in the arguments that Mr. Chirico put forward with respect to the criminal conviction of Mr. Z. It's our position that even if collateral estoppel is not being employed to decide the summary judgment motion, not only is there an overwhelming record in the criminal action, which can stand for evidence on the summary judgment decision, but there was additional record that was developed, as Mr. Chirico mentioned, i.e. the affidavit of Ms. Hazlitt, which have established that there is no issue of fact, and the court was correct in deciding as a matter of law that Mr. Z has no interest in the subject property. With respect to the cross appeal, Justice Edmeade was correct in granting community re-argument on the issue of whether or not the El Peridian lease was at issue in the court below in the original motion practice. Specifically, I've pointed to the affidavits of Joseph McConney and Jim Demetrio, which both allege that there was never any production of the 99-year lease. There was solely a memorandum of lease that was discussed by Ms. Hazlitt. Now, by bringing up this issue, it was squarely the issue of whether or not the memorandum of lease could substitute for the 99-year lease under both the best evidence and statute of fraud standards was squarely before the court when it decided the ultimate re-argument motion and issued its final decision, adjudging the community to be the owner of the building free and clear from the El Peridian lease. El Peridian and the other parties could not establish that there was any leasehold interest that would be.
Was there an acknowledgement, however, in your purchase? How much did you pay for the building, by the way? $10, right?
That's the recorded consideration, Justice Moulton.
And when in the agreement, doesn't it say subject to the lease, the El Peridian 99-year lease? Doesn't it say that?
Well, subsequently to that, it was discovered that there was no lease. There was simply a memorandum that was issued by parties who were affiliated with El Peridian. And even if the contract cites that, Justice Moulton, you still have to be able to establish that a lease actually existed. So the real issue for this court to determine with respect to the leasehold is whether or not this memorandum that doesn't recite anything other than the amount of years and the property is sufficient.
Well, in terms of the memorandum, it stated the names and addresses. It made reference to the lease. It had an execution date, had a description of the premises, and everything else that is required for a memorandum of lease. And so why can't a court credit that if they find that there was a reasonable explanation as to why the lease is not presented? Why isn't this sufficient?
Justice Pitt, you're correct, and that is sufficient perhaps to be a memorandum of lease, but it can't stand for a lease itself. When you have a memorandum of lease that is just out there without an underlying document, it's insufficient, both under the best evidence and statute of fraud standards.
But if there's an adequate explanation for the failure, for the absence of the original, can't it be substituted under the best evidence rule?
No, it cannot, Justice Gesmer. And the reason why is because there are certain material terms that must be present in order for a lease to be found under the best evidence and statute of fraud standards. Most importantly is the rent term. If you look at the Joseph Martin delicatessen case that we've cited, the court latched on to the idea that if you don't have a rent term, then that is facially insufficient in order for a writing to establish the key terms for a lease.
And it's irrelevant that Ms. Wojcicki, whose property it was before she gave it to you for $10, that she also says that was not the intention. It was that they were not supposed to come into possession until the end of 99 years. That's irrelevant too.
Well, no, Justice Renwick. It's not an irrelevancy, but it does not trump the legal issue itself. There are plenty of individuals who intend to do something, yet legally they don't take the necessary steps in order to protect their rights or to establish what they want to do. And in here, the parties had plenty of time to actually create an actual lease. No lease was ever created. Ms. Hazlitt doesn't have any personal knowledge.
We don't know that no lease was ever created. We know that right now they can't find any lease. Everyone seems to be dead, but there's only the memorandum of lease. That much we know.
Ms. Hazlitt is not dead. I don't believe at this point.
Right, but she can't find the lease.
Well, exactly. So the court has to employ the appropriate legal standard, which is, can this memorandum substitute for the lease itself? It cannot. Most specifically because there's no lease, there's no rental term. Just by naming the premises and a number of years is insufficient to meet the standards for the tests that we've set forth in our brief, both under the best evidence and statute of frauds.
On back to you, Mr. Zabrowski.
Thank you, Your Honor. You've heard my argument. I don't need to repeat it. I just want to say what I said before. This is the fact pattern here. I've been practicing real estate law for over 30 years. I've never encountered something like this. Never. there are a lot of factual issues in dispute here. This case calls to be sent back for discovery. And then if they want to make a motion for summary judgment with proof, independent of the criminal conviction, that the documents are, the recorded documents are false, and that the statements by John Z are false, okay, we'll see what happens then. But everything stems from the evidence adduced at trial, and therefore cannot be used against my client. Thank you very much.
Thank you
have a
all.
wonderful day.
Thank you. Healy versus BOP 1 North. Appellants?
I'm the appellant, Your Honor. My name is Carl. Hello? Can you hear me, Your Honor?
You seem to be going in and out. Do you have another device on?
No, I do not.
Okay, you're better now. Go ahead.
Okay, very good. I'm terribly sorry. My name is Carl Lustig. I represent the plaintiff in this case. I'm with the law firm of REA, Lustig, and Sassauer. It's respectfully submitted that the court below should have granted summary judgment to my client. There's no question whatsoever that he was given a device that was inadequate for the job that he was assigned to do. It did not elevate him to the point where he could safely do it by standing on the floor of the man lift. It was blocked by ductwork that had been recently installed. He could not get up there, and consequently, in order to reach the point where he had to work, to hold the steel channel while it was being welded, required him to get up on the railings of the man lift.
Mr. Lustig, I have a question. Was the man lift supplied to him by his employer, and did he have any other safety devices available to him to do the work to which he'd been assigned?
It was supplied to him by his employer. He was given a harness which he had on and which was attached and which was there to protect him from falling outside of the man lift. In this case, when he was shocked, he fell inside of the man lift. But that's the extent of it, Your Honor.
Thank you.
When
Mr.
he
Lustig
decided to, I'm sorry, Peter.
Go ahead, Justice Pitt, go ahead.
When he decided to climb on top of the railing to assist with the hoisting so that the welding work, was there an option to go back down and do that work? And the choice to stand on the railing is really what the issue is here.
Well, Your Honor, I understand what you're saying. I know that's an argument that was put forward by the respondent. However, there's no testimony in the record. There's no evidence. There's no suggestion whatsoever that that was something that my client and his coworker should have done. They already had the welding equipment up on the mezzanine. It was already elevated. They were prepared. They were actually in the process of doing the welding. And there's nothing to suggest whatsoever that that's what they were supposed to do, nor is there anything to suggest that that was an industry requirement or an industry standard. Indeed, there's the records.
Rodriguez, if I could just ask,
certainly,
your client's decision to stand on the railing of the man lift, isn't that an improper use of that equipment?
Well, Your Honor, is it an improper use of the equipment? Certainly somebody should not stand on the guardrails. However, this was done by iron workers all the time. It was done on this job. They were forced to do it, to do the structural steel work at the ceilings, because they were blocked out by the ductwork that had previously been installed. So effectively what happened was a general contractor, in improper sequencing of the job, forced these workers who went up there to stand on the railing so that they could get to the point where they were doing their work. Now, in this case, all my client and his partner, Mr. Shepard, were doing was switching clips. This isn't like a big deal. The clip was fabricated on the wrong side of the steel channel, and they were simply putting it on the other side of the channel. And that was it. It wasn't like a job that requires a whole thing taking it down, along with the welding equipment, along with everything else. This was something that these workers did all the time, and the record's replete with that. The defense acknowledges the fact that they saw workers standing on railings to do their work. Mr. White, Blackbird's own owner, testified this is done, and they know it's done. So this is not something that's unusual. This was not something that was out of the ordinary. These are iron workers doing what iron workers do. He was given a job. He went to do it. He did it. And he did it with equipment that was inadequate for its purpose. Now, I'll add to that. There was testimony by Mr. Roberti from Magan that they could have cut out the ductwork, and which they should have not installed in the first place. That goes without question. But they could have cut it out, but that would have cost more money. So instead of spending a little extra money to cut the ductwork out so my client could elevate all the way to where he had to do his work, they rolled the dice that he could do this however he did it, and it would be okay. Unfortunately, they rolled the dice. It was a bad bet because my client obviously didn't work out that way.
Thank you. Attorney for JT Megan is next with 3 minutes.
Yes, may it please the court. I think that it's very important that the court focuses exactly on what the task was that the plaintiff was assigned to do. What we know from the record evidence is that the plaintiff was assigned to do fit-up work. And we know from the plaintiff's own testimony at 736, he says what that involved was basically staging the beam to see if there were any problems. And he was asked specifically on 736, lines 3 through 13, he was asked, were you able to successfully place the channel on top of the beam prior to your accident? And he said that they did not weld it in place, but they were able to, quote, get it into the place where it needed to be, end quote. And it was at that point that they discovered that there was this error, that there was a fabrication error. Now, what the plaintiff said after that was that they decided to go ahead and refabricate the beam. Now, that's the only testimony we have that any of the work the plaintiff was assigned to do would involve refabrication in order to address the error. And the plaintiff repeatedly says, we were able to do it. This is what we did. The one thing that's entirely missing is any evidence that is from any source other than the plaintiff that his fit-up work required him to do a mid-air field fabrication. And the only evidence we have of what fit-up work would even possibly involve in terms of welding or non-welding is just this distinction that his employer makes between fit-up work and production welding. Welding.
Can I ask you a question? I don't recall any evidence in the record to show that your client said that the moving the clip was beyond the scope of plaintiff's job at that time. Is there any such evidence?
No, and the Court of Appeals said that there doesn't need to be. In Ortiz versus Varsity Holdings back in 2011, the court specifically said that even without the court says without contradictory evidence from the defendants, the plaintiff's own affidavit simply stating that he needed to work at an elevation is quote, not sufficient by itself for plaintiff to win summary judgment on a Labor Law 240 case. The plaintiff has to prove that his case falls within the purview of Labor Law 240, which means he has to prove that his assigned task required him to work at an elevation. Now, doing the fit-up work required him to work at an elevation, and he said he was able to put the beam up where it needed to be, to put it into place to stage it. Now, the only issue
they didn't say that they were able to let it go and leave it there. I mean, the clip was in the wrong place. It was supposed to fit. Can I just finish? I mean, you're saying fit up work. Presumably that means it was supposed to fit there. How is it supposed to fit there with the clip in the wrong place? Isn't that why they had to do it? Are you saying that they should have then brought that beam down?
Yes, Your Honor, fit up, the term fit up, I believe, is a term of art. And the plaintiff, well, it's based on the plaintiff's testimony at 736, he said fit up work means staging it to see if the dimensions were correct. So we did a mock-up to see if it matched the blueprints and if it was fabricated wrong. And basically his
wait, it wasn't brought up there. They could have measured it with a tape measure. It wasn't brought up there just to measure it. It was brought up there to make sure that it fit onto what it was supposed to fit onto. Isn't that right?
Yes, and Your Honor, also at 578 is where his employer says fit up work means basically positioning it in place to see if it prior to being welded in to see if it fits.
Right. So how's it going to fit with a bracket in the wrong place?
Right, well, except that once they put it, the plaintiff specifically says at 736 that they were able to get it up in place. They just noticed that a clip was wrong and needed to be re-welded. And that's the whole point. It's the whole re-welding is whether that was within his assigned task, whether it needed to be performed midair. Now, they were able to get this beam
Okay,
up
I
and
think you
down.
have your point, and you've gone way over 3 minutes. Thank you. We're going on to BOP 1 North End. You're muted.
Thank you. Sorry for that. May it please the court, Patrice Coleman from Pillinger Miller Torello. I agree with my co-respondents' arguments. I'm not going to rehash those, but I would like to go back to Judge Pitt's point, which is completely correct, that there was a choice here. And I think the record makes it very clear that what this plaintiff chose was expediency over safety.
So what choice did he have in order to do the work that he'd been assigned? I don't understand what your claim is as to what choice he actually had.
He very specifically testified on page 737 of the record, lines 6 through 8, that he was able to refabricate the piece without having us all go downstairs. And so this plaintiff very specifically chose, instead of just taking
May
it
I just
down,
ask you something? I'm sorry, because you said you agreed with your co-counsel, and I'm reading on 739, or I think it's somewhere there, that due to the HVAC unit, the plaintiff had to stand on the top rail of the man lift in order to assist with the beam. That's to get the beam into place at all, wasn't it?
I don't think that that's correct, Your Honor. That's not my understanding of the facts of this record. The plaintiff himself testified that the beam was put in place into the hole. It was at the other end that it needed a refabrication, and that instead of taking it back downstairs where they could have put it down and done what they had to do, plaintiff's counsel says that that the man lift was inadequate. The plaintiff himself testified that there was no other device that could have been adequate under that. And so what they had to do and what they should have done was to bring it downstairs, or at the very least seek some other alternative.
Counsel, isn't that shifting the burden on the plaintiff when the law specifically places the burden on the employer that they're supposed to provide an adequate safety device from inception?
Right.
And that apparently didn't happen here.
Well, Your Honor, respectfully, I would say that the device, and in fact, the lower court found that the device was adequate. The plaintiff himself testified.
There's a difference between the device not being damaged or something and the device being adequate. Adequate would mean that it could go through the HVAC and there was no problem, but it couldn't get up to the HVAC.
I think the device was adequate, and I think this was the point that the co-respondent was trying to make, that
I understood. I mean, but I think there's an issue with regard to what, well, I speak for myself, that there may be an issue as to whether or not he was on the railing in order to get this thing through that hole in the first place before the welding even began. Well, and I think that your co-counsel was relying on one word to make that distinction. But even so, if he was contributory negligent, that wouldn't avoid 240.
Absolutely, but I don't think that that's what's happened here. I think that the plaintiff's end of this beam was put into the hole in the wall, and then the plaintiff chose to stand on a rail and sort of keep it on his shoulder, this like 80-pound beam, while at the other end, it was his coworker who couldn't actually navigate it into the hole and had to refabricate.
How do you respond to your adversary's statement that was ordinarily and routinely done as part of the trade?
Well, first of all, I don't think that that's in the record, and second of all, there's no evidence that the safety device that this plaintiff was provided was inadequate for what he was doing. The evidence.
So are you saying that he could have achieved his objection of structurally reinforcing one of the beams, despite the fact that the ductwork was there, they could have done so safely without stepping on top of the railing.
Yes, the ductwork made it impossible for them to retrofit the other end that his coworker was holding. And
Counsel, say that, sorry to interrupt you, but so say they didn't need to do the field modification, say that the clip problem was not a problem. It was, he didn't have to stand on the rail to put this item on the beam?
I mean, I don't read the record as saying that he would have had to do that he would have been able to. What he was unable to do, he was unable to do it because the piece had to be retrofitted. And so this accident happened as a result of the plaintiff choosing to do that modification in midair, as opposed to taking the time, you know, that being expedient, as opposed to taking the time to bring it downstairs. You know, plaintiff's making the point that nobody wanted to take out the HVAC, but plaintiff himself, I mean, that's the sole proximate cause of this accident, was plaintiff choosing, knowing that it couldn't be done otherwise, and choosing to do it anyway. And I think that puts this case in line with Blake, in line with Robinson, and those cases. If I could, unless there's something else on that, I would just like to also address.
Time is up, so just take 30 seconds for your next.
Okay. There's also the 241-6 claim, which is addressed in our brief. I don't think that claim should have been dismissed by the lower court. That section is eye protective gear, which has nothing to do with this accident. There's no proof. You know, general protective equipment does not come within 241-6, and I think the court erred in not granting that part of our motion. It's point 3 in our brief.
Yes, we're aware of it.
I appreciate it.
Any questions? Okay, thank you.
Thank you, Your Honor.
We're back to Mr. Healy. I'm sorry.
That's okay. That's all right. I've been called worse. Look, the fact of the matter is that this was all one operation. They were bringing up that channel to reinforce the beam. They got there. They saw the clip was on the wrong side. They did exactly what they were supposed to do, which is switch it over and change and to the other side. That's
so
what
is that counsel? Is that your response to the contention by opposing counsel that what your client did was really extraneous to the work he was assigned?
No, that's that was all part and parcel of the same job. That was it. I mean, this is what they wanted to do. All they had to do was re-weld it on the opposite side, and the job was done. The idea that he was supposed to bring it down to the floor or that with all the equipment, that is made up. There's no evidence in this record whatsoever to suggest that. Not one construction worker, not one iron worker even remotely hinted at that. What that is,
if the clips had been aligned properly, would he have ever had to get up on the railing of a man lift? Do we know that? In other words, if they could have just placed the item onto the beam without any difficulty with respect to the clips, would the plaintiff ever have had to climb up the railing of the man lift? Is that in the record?
Your Honor, clearly yes. His job was to get up there and hold that channel in place so that his partner on the other side of the wall could do the welding. That was his job. There's no way of getting up that high unless he stood on the top of the railing.
Let me ask you, there's a hole. How long is this beam? How long was the beam?
I think the beam was either 12 feet or 18 feet. It weighed about 80 pounds. I mean, not the beam, excuse me, the channel. The channel.
The channel, yes. Okay. And he had to get it. He had to get it up there alone. Is that right?
Yes. He was the one who had the beam. It was on the top of the man lift. He then had to lift it in place, slide it through the hole where his partner was.
Because it couldn't get to the point of the hole, right? It couldn't get to the point of the hole. That's how he got it up there, was leaning it on the railing.
Correct.
Is that it? Is that what you're saying?
Yes, that's correct. It was reinforcing a ceiling beam.
So that it could go through the hole. And then he had to lift it so it could go through the hole. And then his partner inside had to pull it through the hole, right?
Well, I'm not sure about whether he had to pull it or not, but in any event, they had to get it through the hole so his partner can do the welding on the other side of that wall. My
Well, let me
client,
just ask you, was the 12 feet of the beam supposed to remain on the man lift?
no.
It was supposed to go inside the whole thing, right?
It was supposed to go inside the hole. It was a
And
channel
there was no one
reinforced with
there,
ceiling beam.
and there was no one in the man lift other than he and the channel, the C channel, right? And that channel had to go through the wall, right?
Exactly it. The job was to elevate it and weld it to an existing ceiling beam to reinforce it. There's no way he could have gotten up there except on standing on the railing.
Thank you. Ms. Coleman, I believe, was this a cross appeal? No.
We were appealing the 241-6. We were responding.
Okay.
The plaintiffs to the denial of our summary judgment. We were appealing that as well. So yes.
Okay, so you have 1 minute.
Well, Your Honor, I unless there's some other questions from the court, I think we've covered it. I just would like to say I'm not sure of the page in the record, but the plaintiff's end, he testified that his end was placed in the cutout at the time that this accident happened. So his end was already.
The question isn't that the end was in. The question is how he got the end in. A 12-foot beam, he and the 12-foot beam, you're saying, wow, he picked up this 80-pound thing, but he couldn't have held it up from the ground up there. Well, it had to have been leaning on something, right?
He had his coworker. They moved that.
No, he was in the man lift on his own, right?
Yeah.
With the 12-foot beam, right?
Yeah, but Your Honor, that beam, he testified, and again, it's in the record. He testified that the beam was in the cutout, and that when they needed to retrofit it, then he climbed up.
My question to you is,
it had already been placed. So
my question to you is, was he the one who brought the beam up? Was the plaintiff the one who brought the beam up?
He brought his end, yes.
His end?
Well, there were two ends. There were two workers.
Okay. He had to go 18 to 20 feet up. Where was the other worker? Wasn't with him in the man lift, right?
Wasn't Mr. Shepard on a ladder on the other side of the hole?
On the other side, yeah.
On the other side of the hole.
So doesn't that mean, as Justice Renwick is saying, that the plaintiff had to bring the beam up via the man lift?
And he did it. What I guess the point is that the beam got placed into the hole without him climbing up. At least my reading of the record and the testimony is that he went up on the railing so that he could support the beam on his shoulder while his coworker did this welding retrofit, midair retrofit, and that he would never have had to climb up on that and there's no evidence, Mr. Lester, says that, but I don't think there's any testimony that supports that he had to climb on the railing in order to get that piece in.
Counsel, what was the plaintiff's task? Was it his task to structurally reinforce one of the beams, or was it, as you say, to stage it to see if it fits solely? Because those are two very different things.
I'm sorry, Your Honor, I'm not sure I understand your question.
What was his original task? Because my understanding was that it was to structurally reinforce one of the beams, right? That's more of a general task. Where I heard you argue earlier that he was just supposed to stage it to see if it fit, and once he determined it didn't fit, he was supposed to bring it down. Which one is it?
Well, I think they were up there to see if it fit, and when they saw that the piece did not comport with the blueprints, they should have brought it down, and they chose not to do that. And that's when the accident occurred, and that's what caused this accident.
Okay, I have trouble understanding how you think that what's your take on how long the beam was?
I don't know, perhaps.
Don't worry, you don't have to look at it. In any case, I think we understand. Thank you very much.
Thank you, Your Honor.
FM Cost versus 42 West 35th Street property.
Good afternoon, Your Honors. Robert Levy, Banton Levy. May it please the court, I'd like to introduce James Bell of Bell & Bell of Philadelphia, Pennsylvania, to the court. He was admitted in this matter pro hoc in October of 2021. He's filed a notice of appearance for argument, and we'd respectfully request that Mr. Bell be permitted to argue on behalf of the appellant.
Okay, I will permit it. We have hundreds of thousands of lawyers in New York, quite up to task, but Mr. Bell, welcome.
May it please the court. Thank you, Your Honor, for and this august panel for allowing me to appear, as they say in English, for this turn. First, I'd like to apologize. As I was preparing for this, I realized that the brief I submitted, unfortunately, did not do something that I generally think should always be done in a motion to dismiss matter, which is of the 84 paragraphs that were presented to the learned trial judge, we didn't specifically identify for the appeals panel which of the provisions were actually in issue or that would support or defend the issues in this case. There are only 16 of the 84, and if it please the court, I would point them out unless Your Honor feels that's not necessary.
I think you only have 5 minutes. You've used up one. You should get right to the heart of your argument.
Yes, Your Honor. The first argument is that the learned trial judge dismissed the quasi-contract claims, promissory estoppel, and unjust enrichment against Plus 42. Plus 42 was a signatory to the contract at issue in this matter. It would seem, based on the law cited in plaintiff's brief, plaintiff appellant's brief, especially at pages 11 and 12, that
Counsel, let me just stop you and ask you a question. From what I understand, FMCC signed a contract that only has Plus 42 as the signatory of the contract. They're the only ones who signed the contract. There was another contract that was signed by Bedford Property. And now the FMCC is saying that they're entitled to all money, and defendant is saying, well, Meadow and Hotel weren't part of the contract that they signed. Only Plus 42 was part of the contract. And with regard to the other money, Bedford Property got paid. He got paid for the work he did in Bedford Property, and that was part of a completely different contract. So how is counsel, believing that he should be, counsel, how is plaintiff believing that he should be reimbursed for a contract that didn't involve these other two individuals, the other two companies, Meadow and Hotel Asset Value?
Well, that's a two-part question, Your Honor. The first
it is. I'm sorry.
The first is he had asserted claims in quasi-contract, promissory estoppel, and unjust enrichment against those defendants as well, which were also dismissed in addition to his attempt to sue them in contract. I'm sorry.
It seems like there's a it seems like there is a clear contract between him and Plus 42 for this work. Why would we need to have the quasi contract? Why do we need to have equitable relief where there's a contract here covering that same subject matter?
Well, Your Honor, there's a multiplicity of reasons. Although I'm not sure that it's specifically alleged in the complaint. We see Plus 42 as a shell corporation of the two Meadow and
but you didn't make any allegations of that. Or
no, Your Honor, we made instead allegations that they were completely dominated by those companies and that they were owned by those companies. We did not allege that they didn't have any assets, and I don't actually know, even after discovery, the extent of their assets. But that wasn't before the trial court, Your Honor. What's at issue in considering whether quasi-contract can be pursued against a non-signatory stranger to the contract is the same things that are at issue when determining in general whether equitable relief and quasi-contract are available.
Counsel, let me, I don't mean to interrupt you, but if we were to get to that argument, wouldn't we have to find first that you properly alleged the alter ego or the veil piercing? Because otherwise it's just a contract between Plus 42 and FMCC for which there is no quasi-contract relief.
There is quasi-contract relief where the interest of justice so requires, which if you consider it as really a tautology, because that is also the situation in which quasi-contract applies. And the answer to that question here is that Meadow, the company, reached out to FMCC and asked it to perform work on its behalf on one of its properties, that the contract with Plus 42 was negotiated only between FMCC and representatives of Meadow and Hotel Avenue, and not anybody in particular who is identified as belonging to Plus 42. Those things are also alleged in the complaint, and it is further as regards the equitable interests. It is alleged, and it's alleged because I believe it to be the case, that as the owners in this instance, that Hotel Avenue and Meadow both benefited strongly from the $2 million tax reduction that my clients were able to obtain for them. And so we believe that in this circumstance, having negotiated a contract with these parent corporations only, that and having been represented to that this work was for them, would benefit them, and at one point in the negotiations, which is also mentioned in the complaint, that in the event that the full monies for the contract revenue had to be paid over to FMCC, that it would be Meadow and Hotel Avenue persons who would need to contribute to that money. So it was clearly everyone's money.
Thank you, counsel. Let's hear from opposing counsel.
Thank you, Your Honor. May it please the court, Daniel Cohen, Malden, Mockton, Heron, for the respondents. This is a simple breach of contract case, as you've indicated. There is a written contract. There is a signatory to the contract. The dispute concerns payment under the contract. The complaint clearly alleges that the plaintiff performed services under the contract and seeks the contractual due.
And counsel, let me just interject. Also, FMCC had done work already for Hotel Ave in the past, correct? Before taking on this work. And the point that I'm trying to make is that it was aware of the various entities. It had also done some work for Bedford property, correct?
Correct. So it was aware.
Wouldn't that indicate that, if they were concerned about this, they could have put those entities' names into this contract in addition to Plus 42?
You are making my argument for me, so I'm grateful. And of course, there's a First Department decision right on point called Sanska, which is cited in our brief, which says exactly that. So jumping ahead, I think, to that issue, we cite law on page 17 of our brief, settled law in the First Department, and otherwise, that where a contract covers the subject matter, there is no contract claim against non-signatories. There's also no non-contract, quasi-contract, promissory estoppel, unjust enrichment claim against non-signatories for the same reason, all flowing from Clark Fitzpatrick. And then we're left with this veil-piercing claim, which isn't actually pled. There are conclusory allegations of domination and control, but they're merely conclusory, and they don't overcome the point, Justice Moulton, that you just made, which is twofold. And again, I refer to the Stanska case. 2 points. One is that a contract claim, a simple breach of contract claim, does not become transmuted into a veil-piercing claim where there's no allegation of any fraud, and appellant's counsel conceded he doesn't make any allegation. In fact, he makes no allegation that this is a shell. But regardless, you've made the other point, which is there are ways to contract to make as a guarantor or an additional party, any party that you think should be a party to the contract. Appellant didn't do so. The assessment was against the contracting entity. It was the contracting entity that was under audit by the state. And that's exactly why the contract reads the way it reads. If there are no further questions, I'll rest.
Thank you. Mr. Bell, you have 1 minute.
First, with respect to the quasi-contract claims against Plus 42 or against Hotel Ave and the other entity, I would call the court's attention specifically to the Matthews case on page 22 of the brief, which I believe is very factually similar as regards the negotiation and promises made by third parties to the contract in the interest of justice. With respect to the idea that the support for either a third-party beneficiary claim, an alter ego claim, or a claim that the companies were so closely related that justice would suggest that they ought to be held liable, I would point out with respect to this language, courts sometimes trot out the language that some particular allegation in a complaint is conclusory or non-factual, and that's not entitled to the same factual and truthfulness presumption as other allegations might be in determining a motion to dismiss. I would point out to the court that these particular allegations, complete and total domination or ownership, I'm not sure what's, it's complicated because as I thought about it, I'm not sure what subfacts you plead other than company A completely dominates and controls company B. Do you need to say who dominated them on what day or which specific officer of the company stepped in for the other? We have identified who it was from company B and C who negotiated on behalf of company A, and the absence of people from company A being part of the negotiations or asking for the work to be done. And as a result, I think that our allegations about the companies being run as one consolidated enterprise and being the alter ego and one controlling the other are exactly how it appeared from my client's vantage point and the facts that they know and that they alleged. I'm not sure how they could have been more specific so as to render it not something that you might call conclusory because they said they're the alter ego, etc.
Thank you. We understand your point. Thank you.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honor.
You're welcome. Hughes, sorry. Hughes versus the New York City Loft Board.
Good afternoon. May it please the court. My name is Margaret Sandercock, and I represent the appellant Frank Hughes. I hope to
Counsel,
be able to make...
I'm sorry.
Yes,
I was just going to ask you a question. Did you finish with your appearance?
I did, Judge. Yes.
Oh, okay. I just wanted to ask you, the loft board is pretty clear. The loft law is pretty clear that you have to be the resident. You have to be a primary resident of the particular property. And this person had moved out, right? He had moved out, moved in with his girlfriend, changed the property, rented various units out, and had even rented his unit out. So how is he the primary residence here?
Your Honor, I believe that you've misunderstood some of the facts here.
Okay.
Mr. Hughes certainly did not permanently vacate. He only rented his own room for 7 months out of the 14-year period that is at this time before the court. He always had roommates when he lived there. He did not charge his roommates anything more than the rent that he was paying to the landlord, plus the utilities and other expenses for the space. He did not.
Ms. Sandercock, isn't it true that he also didn't live there? I mean, whether or not he rented it out, if he wasn't living there, then it wasn't his primary residence, right?
Well, in the first place, Justice Gessmer, I do want to point out that at the time Mr. Hughes had his coverage hearing, primary residence was not part of what was required to prove protected occupancy.
It's been required since 1992, hasn't it?
No, Judge, all the loft board precedents, and we cited many of them in our main brief at pages 14 and 15, required you to prove that the place was a residence during the base dates of the law. For Mr. Hughes, in this case, that was 2008 through 2010. Therefore, the only evidence that we offered on his behalf, and also on behalf of all his neighbors who also got protected, was proof from 2008, 2009, and 2010. What Mr. Hughes had as his reasonable expectation in light of the loft board precedents was that he would have to become a primary resident if he gained protection. And if he did not, he would be evicted by means of the housing court, as the loft board lacks jurisdiction over primary residence issues.
I'm confused. The property was a residence to other people, for sure. But I don't see how it was his primary residence for the entire time.
It is our contention, Your Honor, that it did not have to be under the law at the time of his hearing. Those loft board decisions are cited in our brief at pages 14 and 15.
Yes, I heard you say that.
Counsel, how do you get around the multiple dwelling law that says, quote, provided that the unit is their primary residence, unquote? That's in the multiple dwelling law. That's the statute. It's also in the regulations.
Right, and that's the part that's been in existence since 1992.
Your Honor, the loft board's own regulations say that they lack jurisdiction to make any determinations of primary residence. And it's the very definition of arbitrary and capricious for the loft board without advance notice and without using the City Administrative Procedure Act to, in a piecemeal fashion, decide cases between 2014 and 2017 after Mr. Hughes' hearing testimony, which changed their policy. There was so much criticism.
I don't understand what you're saying about changing their policy. If the multiple dwelling law has said since 1992 that a covered occupant has to show that the unit's their primary residence, and I don't see where the arbitrariness and capriciousness comes from.
Your Honor, it has to be your primary residence once you get covered. There's decisional authority from both.
Wait a second. They can't. Wait. He makes the application. He made the application. Once you make the application, it presumes that at the time you make the application, you're going to be continuing as a resident. They receive the application. They have to consider the application, and when they're considering the application, he's not there. He's with his girlfriend.
Your Honor, with all due respect, we do not believe that he had to be a primary resident at the time of his hearing. There are many loft board precedents which say so. He had to become a primary resident once he got protected. We have cited in our brief, among other things, a Court of Appeals decision that says that if you're applying for a rent-regulated tenancy, you do not have to adhere to the rules of that rent-regulated tenancy until the time that you actually become rent-regulated. So moving along from that, because the loft board made a massive change of policy between 2014 and 17, the loft board did re-summarize the policy in a decision in 2017, but every prong of the policy was not known until 2019 in the case that we have cited that concerns the building 400 South 2nd Street, and that was in 2019. What the loft board ought to have done instead was to promulgate regulations under the City Administrative Procedure Act so people could have advance notice of what it was that they needed to show. What would Mr. Hughes have shown?
Counsel, isn't the advance notice provided in the multiple dwelling law itself that had this requirement since 1992? What I hear you to say is that despite this requirement in the multiple dwelling law, that the loft board issued decisions that basically didn't follow the multiple dwelling law.
No, Your Honor, it is a basic rule of law in rent-regulated tenancies that you don't have to behave according to the rules of a rent-regulated tenant prior to the time.
So I just want to know, is this arbitrary and capricious? Because that's you didn't go under a substantial evidence. You just went pursuant to arbitrary and capriciousness.
No, Your Honor, we didn't want to go under substantial evidence. And the reason that we did not.
Is this arbitrary and capricious, this finding by the loft board based on these facts?
It is arbitrary and capricious in the nth degree in two ways. Because of their departure from all their prior precedents that we cited in page 14 and 15 of our brief. And secondly, because other people who were caught in this same situation received remands of their cases. There are loft board decisions under which people who are temporarily absent, but who maintain a nexus with the premises are entitled to retain their protected status. One example of such cases is matter of Pels, which is cited in our brief. Mr. Hughes took his clothes and his bicycle when he went to his girlfriend's. He did not have an occupancy agreement there. He left just about everything that he owned in the loft.
Didn't he rent it? Didn't he rent it for his own place?
There are 4 or 5 bedrooms in that unit. He has always had roommates, whether
Yes, I know.
whether it wasn't.
Didn't he rent his
own bedroom for 7 months?
Yeah,
to
so
a
he
friend.
rented his own bedroom with everything in it. What difference does it make that everything was in it? He rented it to someone else.
Well, Your Honor, he
Anyway,
never
I
had
think we have your point and we've gone way over time. You have some rebuttal. Let's get to opposing counsel.
May it please the court, Boris Lepik from the law office of Tzad Rothenberg, and I represent the respondent Dasa Realty. Just wanted to add on a few points that almost all of your honors had raised, and that multiple dwelling law section 286 subsection 2 since 1992 provided for a primary residency requirement to be established when an occupant seeks a protected occupancy status.
Well, counsel, I think that the argument is being made that they implemented different practices. And so for them to vary from that now is what makes it arbitrary and capricious.
Well, also in my brief, I also cite a matter of Shmulka, which was issued in 1996. Also recognizing within its own rules that the loft board had developed, which also reiterate the requirement of a primary residency when a subleasee, not a tenant of the apartment, but a subleasee is the one seeking protected occupancy status, has to be a primary resident of that particular apartment when the application is filed. And that case was issued in 1996, and that particular provision was in existence in 1996. It was not a new practice for the loft board to require this primary residency requirement. It was.
Well, he's saying that he was he's saying he was living in it when he filed the application. Then he left immediately thereafter.
Right, and that's not in dispute. But I think what the crucial factor is that while the application is pending, both the loft board rules and the multiple dwelling law provide for a current status of primary occupancy, not the one that may have existed in the past, but currently, as of the time here. And throughout the entirety years of adducing testimony in this particular loft board proceeding, he did not reside in this unit. And
let me just ask you a question about the primary residency, right? He moved in with his girlfriend, or he went to stay with his girlfriend. He left all of his belongings there. He didn't change his voter registration. He didn't change taxes. Like he left a cat there. I mean, why is that not his primary residence?
He was in there for 3 years, I believe, Justice Pitt. He came back according to the testimony in 2015. So between 2012 and 2015, he lived someplace else. I think, we can't ignore, the other factors that were adduced, in the fact that he did rent out this particular apartment. He did rent it fully furnished. He collected rent from individuals not occupying just his particular room, but the entire apartment as a whole, for which he seeks protected occupancy status. I think those factors coupled together show that he moved on someplace else for that time being. And then when he came back and he realized that his absence is not going to hurt his case, now he wants a second bite of the apple. And unfortunately, there's no dispute, Judge, as to the evidence or the weight of the evidence. The only question is whether or not, at least on this appeal, is whether or not the loft board applied a new standard that had previously not existed. And unfortunately, Judge, as you all had pointed it out, going back to 1992 and in 1996, the decision of Shmulka, that primary residency requirement was in existence, and it was not something new that the appellant had to address in his trial testimony.
Thank you. Let's hear from the loft board.
Good afternoon, Mackenzie Phillip for the loft board. The loft law is designed to prevent evictions during the lawful conversion process. If you don't live there, you can't be evicted. You're not entitled to the protection of the law. Frankly, this as your honors noted, the law itself requires primary residence. So it really doesn't matter what the board's rule says or what the board did in the past. The law is the law. But I would note that there has been no change in what the board has been doing.
Ms. Phillip, would you address Ms. Sandercock's contention that that's not a requirement until somebody has obtained coverage, and that since he had not yet obtained coverage, it wasn't required of him?
Yes, she's just misreading the precedents. So basically, the board makes two decisions. Is the building a covered building? And in that coverage determination, primary residence is not relevant. Then it makes a protected occupancy determination. Who is protected and entitled to continue living in the building while the conversion process goes through? And in that analysis, primary residence is relevant, has been for decades, at least since 1992. The board's rule has required primary residence for even longer, since I believe 1983. So I think that council is just conflating these two analyses. And perhaps I wouldn't even really concede this, but perhaps if the board made these decisions separately, like decides coverage and then a year later decides protected status, maybe it would matter, that something changed in between. But the board here made the decision all at once based on the one record, and it always does that as far as I can tell. All the decisions make both analyses in the same decision. And there are many cases from before April 2014, when the petitioner testified here, where the board said you had to be a primary resident to have protected status. There's a case called Matter of Gherkin, which petitioner herself cites from 2013, where the board specifically said you have to use the unit as your primary residence to have protected status at the time of the hearing. There's a case from 1997, Matter of DeGraw. There's a case from the early 90s, Matter of Schlesinger. There has been no change in the law. There has been a dispute between Oath and the board about a completely separate matter that council is trying to confuse the issue about when various people are entitled to protected status, who gets priority. But that has nothing to do with this case. Here, the law is clear. Thank you.
Thank you. We're back to you, Ms. Sandra.
Okay. Mr. Hughes never had the opportunity to present evidence to the loft board concerning his intention with respect to the future of the loft, which I think is fairly well indicated by his conduct, paying his taxes from there, being registered to vote from there, and continuing to take care of the place and not rent gouge his roommates. Obviously, this was a person who was going to come back, but who didn't know he had to tell the loft board that. With respect to the authority,
I should have thought that we could judge his intentions by his behavior, and his behavior was that he wasn't living there, and that seems to me more salient than where he signed his taxes from. So perhaps you could explain why where he signed his taxes from was more indicative of his future intent than where he was actually living.
Taxes, voter registration, and driving license are the most preferred proof for use in loft board hearings, and they too are conduct. It's obvious to me that Mr. Hughes did not view his relationship with his girlfriend as being permanent, and he was, and that's
Maybe
what ended up
not, but
happening.
he was there for 3 years.
That is true, but
okay, so 3 years is permanent enough for the loft board, though.
I don't believe it is, Your Honor. I believe if you look at cases like Matter of Pels, Miss Pels was gone from her space repeatedly. She taught in different universities every year, and
but that's a different thing to take jobs temporarily out of the city than to live somewhere else in the city. It's a very, I mean, it's often the case that people who live in New York, even in rent stabilized apartments, take jobs out of the city for year-long periods or other short periods, but this is different from that because he was living somewhere else.
There's, I think, something I need to try to clarify that my adversaries have mentioned. My adversaries
I'll give you
are
30 seconds to do it because we're over time.
My adversaries are talking about a case called Smolka and the fact that you always had to show primary residence. That was only if there was a dispute between a prime tenant and a subtenant as to who should be the protected occupant. So I actually believe that my adversaries are misunderstanding or conflating that. For all these reasons, we request either that the case be remanded so that Mr. Hughes can establish his proof under the new standard, or alternatively, that this court or the trial or after a remand to the trial court, that the prior rules be applied. Thank you.
Thank you all.
Thank you.
Catania versus Liriano.
Good afternoon, Your Honors. May it please the court. Anthony Gentile for plaintiff appellant Patricia Catania. And to comment on something Judge Resnick said, it's an honor and privilege to be an attorney in this state, even though there are 100,000 of us.
Thank you. And I'm Renwick, actually, but thank you.
I apologize for
that. I agree.
The print is a little too small, I'm sorry.
Okay.
There were 3 issues before the court, and unless the court has a preference, I will start with the pleading issue. Now, the pleading issue, I have to concede, I did move for declaratory judgment in my notice of cross motion. I did not move specifically pursuant to section, I believe it's CPR 3001. And we have to ask whether the lower court elevated form over substance. Was this truly a matter that required a full-blown plenary action and full-blown discovery? This was not the classic declaratory judgment scenario where, let's say, there's an insurance coverage issue and there's a lot of facts. This was something the court could have decided basically on papers alone. It was almost a law school question. It was a constitutional law question. There would have been very limited discovery. The court itself admitted that it could have amended the cross motion to be deemed as a complaint. But what stopped the court was the rulings in Palladino and Martin, which will be, of course, my second issue to be argued. So, query whether, and there was a very good reason why.
Counsel, could you move on to those issues, please? I'd really like to get to the substance of it. It seems to me that your counterclaim really asks us to overturn the Court of Appeals decision in Martin versus Curran, which the Court of Appeals expressly declined to do in 2014 in Palladino. So how would it be appropriate for us to do it at this time?
I very humbly and very respectfully disagree with the word overturn. Our position is twofold on this. I know we have it's clear we have these obstacles of 2 Court of Appeals decision. No attorney wants to be in this position, let's be honest. But my client is invested in the long game and the longer game. The long game is getting the Court of Appeals to look at this from a constitutional perspective, which it's never done. The longer game is getting this matter before the Supreme Court, which you have to necessarily take the proper steps. You have to exhaust your appellate remedies, including being before the Court of Appeals and being denied before you could even petition that high court for certiorari. So that's one reason why we're doing this. The other reason, the more important reason, is we don't think these issues have ever been addressed. I've read the Palladino decision carefully and its dissent. I read the Martin decision carefully and its dissent. I've even read some of the briefs that were submitted to the courts in those cases. No one has ever addressed these specific constitutional issues that we're raising. The issue was always, well, this is a little unfair. Unions have evolved and things of that nature, and they address the inequity of it. We have some pinpoint arguments here where we believe this statute, as it's written on its face, is unconstitutional. And there are 6 sections in my brief about that, and some of them are interact and intertwined. And there's due process and there's equal protection and denial of her First Amendment rights. No court has ever looked at.
I don't see on these constitutional issues. It seems that I understand the UFT is not supporting her, but she still has her arguments to be made to a court.
I so apologize. I don't understand what Your Honor meant about the UFT not supporting her.
Well,
that's your adversary. I'm just a little.
She's your client, Ms. Catania.
Yes.
Is arguing that there are constitutional violations here. I don't see how her constitutional obligation.
That's something that the UFT argued in its brief, and I fervently hope the court doesn't take up that mantle. That's not what we're arguing at all. My client actually does have a 1983 claim, but that's not at issue in this case. There are some constitutional violations, but those aren't at issue in this case. What's at issue is the UFT committed intentional torts against her. Some of them bordered on criminality when you read the allegations in the amended complaint. She brought a lengthy complaint, 17 causes of action, and most of them were intentional torts. And what the court said is the Gal statute says you can't sue this type of organization for an intentional tort. You could sue them for negligence, but you can't sue them for intentional torts. So it's the statute that's barring our client from the courthouse door. And that's what we're asking this court to address or send
Isn't
back to
that
the lower
something
courts.
for that's exactly, isn't it something for the legislature to do? Isn't that for the legislature?
I think when a statute is unconstitutional on its face, no, it's for the court. And this is, what if the legislature passed a law that says, okay, if you're in an auto accident, you have a statute of limitations of 7 days. That would be unconstitutional on its face. No one could ever meet that. You're still in the hospital maybe 2 weeks later.
Mr. Gentile, I guess,
ever-
I'm sorry to interrupt you, but I
No,
guess
no.
you could not go to federal court, right? Because there's no diversity and it's not a federal question. So you're stuck with state court, right?
I don't want to mislead this court. We have a strong 1983 claim, and we brought that before we brought that before the Southern District of New York. That's pending at the moment.
So there but wouldn't that vindicate all of
But interestingly, the Gal statute is not at all applicable to 1983 claims.
No,
So
that's
it's really
exactly-
kind of irrelevant in a sense.
Well, it's just that she could vindicate all of her, maybe, I mean, arguably, she could vindicate her rights in federal court. So she's not stopped from going to the courthouse, just not the state courthouse.
Let's be honest. What you get with intentional torts that you don't get with 1983 claims is you get punitive damages, and that's what we're looking for. She was, she certainly had a life and career ruined, and she's entitled to a plethora of compensatory damages. But we don't want this to ever happen to another person again. And we want to send a strong message to the union and to other unions that may be considering this or other general associations. This is unacceptable, and this is what will happen to you if you do this. I mean, if you read the record, it's really egregious the way they went after her.
Okay. Thank you. Let's hear from.
Thank you, Your Honor, for being heard. Thank you.
You have some rebuttal. Counsel for.
Yes, thank you.
Yeah.
Thank you. I'm Megan Murphy. I'm here on behalf of the United Federation of Teachers, Ms. Janella Hines and William Woodruff. And we've heard from appellant about her strong dislike of General Associations Law, Section 13. But as pointed out by this court, these arguments are properly before the legislature and not this court. General Associations Law has withstood challenges for over 70 years, most recently in 2014. And in fact, the real issue in this case is that the appellant failed to raise this issue properly in her complaint. And the lower court determined that it was not required to reach the constitutional arguments that she raised. And the appellant has not put forth any reason why she did not seek leave to amend her complaint. And that's really what's at issue in this appeal. I'd also like to address the individual liability of union officers. As addressed in our papers, the issue of whether individual union officers could be sued in their individual capacity, this was not properly raised below. And it's our contention that appellant has not cited any persuasive authority to abandon the First Department's ruling on this issue.
Thank you. If there's nothing further, we're back to Mr. Gentile for 1 minute.
Thank you for that minute. Council mentions that the statute at issue has withstood numerous challenges. Yes, they were challenges, perhaps in the abstract, not the specific constitutional challenges that we are raising. So we would ask this court to address those in the first instance, or remand it to the Nisi Prius court to address that in the first instance. As to the alleged pleading defect, we were sort of ambushed by defendant, and they shouldn't be rewarded for that. What happened was, this case had been pending for 2 years. We were up to document number 234 in the record. There were 7 motions pending. The court finally said enough is enough. No discovery had been done. And the court held this global conference where it was going to resolve all these motions. And it was decided at that conference, this would be the operative amended complaint. After that amended complaint, despite the fact that UFT had made 2 prior motions, they suddenly, for the first time, moved to dismiss based on the Gal statute. So why would we have had that in our initial complaint? And after all that, we felt we didn't want to burden the court with the motion to amend the pleadings. It seemed easier for the court if we just cross-moved for the court to declare the statute unconstitutional. And we kind of feel like we were trying to do the right thing by the court and no good deed goes unpunished. Or if you want to look at it, maybe the attorney stumbled and made an error. Why should we punish the plaintiff for that? And as to the my last point, as to the status issue of individual liability, I realize there's no First Department cases supporting our issue. I always found it odd that you could be under one set of laws if you live on Canal Street, under a different set of laws if you live on Adams Street. But we asked the court to adopt the holding, the judge like that. We asked the court to adopt the holding of the Second Department, which says, there's a lot of racial animosity and longstanding animosity. You can hold them individually liable. And here there's a plethora of that. If you look at the allegations, you look at the campaign they waged against her, the fact that it was a race-based campaign, the fact that Woodruff didn't like her, thought he was stupid, had a reputation as a principal killer, and kill her he did. And that's my final point. I thank your honors for the opportunity to be heard, an opportunity which we feel we were denied in the lower court and we hope gets rectified.
Thank you. Thank you both.
Thank you.
Thank you.
Yep. We're back up to the middle of the beginning of the calendar. We're going to call Reese versus the City of New York, and Justice Pitt is recused from this case.
Thank you, Your Honors. May it please the court, Alina Drucker on behalf of the city. I'd like to address primarily the cross appeal that the city made here and ask this court to reverse as to the summary judgment decision on the malicious prosecution claim and the damages that come after the discovery of drugs. On the federal claim, it's
also,
just
before we proceed, I just want to get something out there because I think it's going to set the tone for a lot of the ensuing discussion. In reading your brief and your reply brief, it seems to me that the city does not dispute that the bottle was unopened. It also seems to me that the city does not dispute that there was no probable cause based on the open container. Is that your position?
So for the purposes of summary judgment, I think we can see that it's a question of fact. There is a video and the court found that it supported an inference that the...
I'm going to read specifically from your brief. It says, for the purposes of summary judgment, the city does not dispute that the bottle was unopened.
Exactly. For the
Sorry, go ahead.
That's exactly right. So for the purposes of summary judgment, we don't dispute that the bottle is unopened. I think the principle would be that, and can I fold in the legal argument, I think that follows from that question, which is when you have an unlawful stop and an officer, arguably unlawful stop, the officer then finds during a search incident to that unlawful stop and arrest evidence of criminality, drugs, or some evidence that links this person to a murder or to, guns, weapons. The officer isn't under civil law being told now that he has to, or she has
Counsel,
to just
we
let this
understand
person go.
that's your argument. I'm sorry to interrupt you, but that's your argument under Towns. I think Justice Rodriguez is asking you a different question, which is, are you conceding that the initial stop was unlawful?
Oh, for the purposes of summary judgment, yes.
What does that mean?
It means it's a
are you still saying there's an issue of triable fact, or what? Or are you conceding it for the rest of the case?
No, absolutely. That is a triable question of fact. That we didn't. The court denied us summary judgment. So if you were to affirm, there would be a trial on the question of whether or not there was probable cause. The officers testified that the bottle was on, it was screwed on, and that they moved it, and it moved a little, so they thought that the bottle, it wasn't a twist off.
I know the facts. We want to know what your position is with respect to the facts. In other words, are you conceding that the stop was unlawful for the rest of the case, or just for some abstract way for this appeal?
Well, on summary judgment, when there's a question of fact, if it's material, then you don't get summary judgment. You could go to trial.
But counsel,
what we're saying is that fact isn't material for the summary judgment.
The plaintiff moved for a summary judgment on false arrest and false imprisonment, right? And if you are conceding that there was no probable cause for the stop, then he should be granted summary judgment, correct?
No, that's not how it works, Your Honor. I'm sorry. So there was two cross motions, right? There was a motion for summary judgment that the city made. There's a motion for summary judgment that the plaintiff made. The plaintiff was arguing that there's no question of fact that this was an unlawful stop. We were arguing that it doesn't matter whether or not the stop was unlawful. For the claims that we're talking about, there's only one state law claim. It's a malicious prosecution claim. There's no unlawful search claim. There's no state law false arrest claim. So we're saying that for the malicious prosecution claim, this man, Mr. Reese, was prosecuted for drugs, not for the unlawful open container stuff. So we're saying is there is a question of fact about the open container issue, but that is not relevant to, yes, Your Honor?
Yeah, but it's a false arrest. In order to get to the in order to get to your question with regard to the drugs, if there was no basis for the arrest, then how is there a basis to claim that the drugs made it okay?
Because he was arrested for an open container violation, and then he was subsequently searched, and then they found an independent basis for probable cause, which is those drugs.
The independent, but there was the search and there was the arrest, and the search was incident to the arrest. But for the arrest, there would have been no search. There was no intervening act before the finding of the drugs. The drugs were only found because of the arrest. The arrest only happened, the drugs were only found because of the search. The search only happened because of the arrest.
So I think that there's no question of fact about the drugs existing, right? The question is only about whether they're admissible in evidence. In a civil case, when the officer is sued, can he rely on the drugs to explain why he made the arrest? The officer didn't just take this person off the street and then arrest them for drugs without any drugs being found, right? There were drugs. The question is whether those drugs are admissible in a civil case as in the officer's defense to show probable cause. So
yes, but that's not the basis of the arrest. The arrest was the bottle. You're suggesting that the arrest was based on the finding of drugs, but he was already arrested. That's why they were able to search.
There's no false arrest claim here under state law, right?
There's a federal false. He moved for summary judgment on his federal false arrest and false imprisonment claim, and that's part of what's at issue. So if you concede, if you concede for the purposes of summary judgment that there was no basis for the arrest, then why shouldn't we grant summary judgment in his favor on the federal false arrest claim?
I'm saying that, so our motion for summary judgment was not for, it's not for the
I'm not asking you about your motion. I'm asking you about plaintiff's motion. Plaintiff moved for summary judgment on his federal false arrest claim. If you concede that there was no basis for the arrest, why shouldn't we grant summary judgment to plaintiff on his federal false arrest claim? And maybe other federal claims too, but certainly on that one.
We don't concede that there was no basis for the arrest for his federal false arrest claim. We're saying that there is a question of fact, and so that it is triable. There is a triable question of fact about whether or not his initial stop and arrest for the open container was lawful. For that, we'll go to trial, regardless of what you do, because there is a question of fact. We moved for summary judgment for the damages that accrue after the drugs were discovered on the federal claims, the federal malicious prosecution claim, because he was not prosecuted for the open container. He was prosecuted for the drugs. So take the scenario as these are distinct causes of action. So for example, an officer in towns, right? An officer stops a car unlawfully. The officer then finds guns in the trunk that link the plaintiff, the criminal defendant turned plaintiff, to a murder. The law under federal cases is that the officer does not have to let that person go or face civil liability. The officer can rely on that new evidence to show that there was probable cause.
Counsel, I understand that. I want to go back to Justice Rodriguez's question in the first place. On page 5 of your brief, you say, for purposes of summary judgment, the city does not dispute that the bottle was unopened. But part of the summary judgment motion is plaintiff's motion for summary judgment on the false arrest. So are you conceding that claim?
I'm so sorry, Your Honor. Should have been more clear. We concede that there was no question, that there is a question of fact about.
That's not what your brief says.
So for the purposes of our summary judgment motion, we don't dispute it. For the purposes of our summary judgment motion, we obviously dispute that there's a question of fact. But for the purposes of our summary judgment motion, we say that fact doesn't matter. We don't dispute it.
Right, but counsel, you understand how that's different to say that a particular fact doesn't matter and is irrelevant to my question, as opposed to saying that we concede the point, because conceding the point is detrimental to the city.
I'm so sorry, Your Honor. I should have been more clear, and I will submit a revised brief if you'd like. But my point is that we're making a legal argument about what you do when you have evidence that is discovered that currently under federal law, very, very clearly, there's no dispute. I mean, there's no question. It's just a misapplication of federal law. That evidence is admissible in the civil case for showing that the officer had probable cause. So there's no question that the malicious prosecution.
Law, right? That's not the law in New York, in the state, is it?
So what I am arguing is that it is the law in the state. If you read the decision in Martinez, which follows your court's decision in Ostrover, what the decision in Martinez says is that basically the reasoning that underlies Ostrover is no longer good law. In Ostrover, the court said that in a juristic sense, you couldn't use that piece of evidence, the drugs that were discovered, because they were tainted by the sort of it's importing that criminal concept of fruit of the poisonous tree into the civil context. What the court in Martinez did is it first considered the question of whether there's an independent cause of action on the exclude for the evidence that was unlawful search claim. And they said there's no unlawful search claim. And then they said that Melody Martinez, the plaintiff in that case, was arrested based on an unlawful warrant that searched her home that found drugs that were suppressed in her criminal case, but that there was no false arrest claim against the officer based on the drugs, because the drugs were considered as part of the mosaic of evidence that makes up the probable
wait a
cause.
second. Isn't Martinez distinguished, or isn't Ostrover distinguished from Martinez? Because Martinez, I believe there was a confidential informant. And in that instance, that was the intervening cause I was talking about that made the break between the arrest and the finding of the drug, the ability to allow the drugs in, or whatever was found after that. Here, there's the plaintiff's arrest here, or in Ostrover, I believe. In Ostrover, it was undisputed that the plaintiff's arrest was not supported by probable cause. I thought that that was the case in Ostrover.
No, I'm sorry, Your Honor. So Martinez, that's not exactly right. In Martinez, there wasn't an intervening break in the law. What happened is that a confidential informant came to the police and did an uncontrolled buy, an unlawful buy. Based on that,
held in that case was that although the warrant may have been faulty, that they still had independent probable cause for the arrest.
Because of the
drugs. If you read the decision, it says the probable cause is based on the drugs discovered in her dresser. And those drugs are the fruit of the poisonous tree. Those very same drugs were suppressed in her criminal case, which is why her conviction was overturned and she was released from jail. So those very same drugs, the Court of Appeals has clearly held, you can look at drugs that are tainted in a criminal case and in a civil case. And that for the same reason, the U.S. Supreme Court has considered, tainted evidence obtained in that way in every civil context.
Also, even in the federal case, the court there went into great lengths to talk about proximate cause and how there was no break in the causation.
So let me explain that.
There's a break here, right? There's a break here. Here we have a lower court judge finding that the officers were incredible and suppressing the evidence. Isn't that a break?
I think that's backwards. So I think the break, so the question about the causal chain. So
I'm sorry, you're correct. That's not a break. In other words, in the other cases that you're relying on, I misspoke. You're correct. In the other cases, there was a break in that the court found that it was okay.
So you
Right.
just said in the federal cases, absolutely not. So for example, in towns, it's exactly not. So for example, in towns, it's exactly the same scenario, basically. And in every federal case since, I mean, there's no question under federal law, right? The evidence that is obtained.
So is it your position
there's
that evidence that's obtained on, is it your position that evidence that's obtained unlawfully could always be used for probable cause?
No, I think it's a narrower point. The point is, when you have a claim for false arrest, you have a very different what you're talking about here is you have a malicious prosecution claim, and a person is prosecuted on evidence that is subsequently discovered. When there is a previous illegality, there's a cause of action for that. There's a false arrest claim for that. So what Mr. Reese could have done is filed a claim, a timely claim for false arrest. He claims he has an unlawful stop, an unlawful search, and that false arrest claim is what is linked causally to the defendant's conduct, which is, but there's a separate intervening act. This is the intervening thing that breaks the causal chain. The discovery of these drugs.
But where
do you elongate the chain?
The discovery, I'm sorry to interrupt, but the discovery of the drugs is not the intervening act. There had to be something that caused the discovery of the drugs. The discovery of the drugs is the thing. What happened in between the arrest and the discovery of the drugs that makes it okay?
It's not about making it okay. It's about whether that evidence can independently be used in the civil. I'm not talking about like moralistically.
I'm not talking about moralistically.
I mean,
I'm talking about that makes the prosecution of it all right when I say okay.
The point is that the exclusionary rule on the fruit of the poisonous tree is a remedy, a court-created remedy. And what it does is it's a prophylactic rule. The purpose of it is to discourage unlawful searches. And the remedy is that the fruit of that unlawful search is not admitted in a criminal case. What the Court of Appeals said in Martinez is that is remedy enough. You have an unlawful search and they find out that you murdered someone. If that's the only evidence they have on you, you get out. That is your remedy when you have had an unlawful search. You don't also then get to take that unlawful search and immunize all your future in criminal conduct, and then also turn around and sue the officers for arresting you. And I think that a good way to think about it is if you think about what is the question for the officer there, upon finding these drugs, you're saying if the officer thinks there's I don't know whether or not whether this evidence will ultimately be admitted or not. But if a prosecutor decides to use it and the prosecutor and the judge ultimately lets it in, then I'll be civilly liable. So I'm just going to let this person go. That is what this rule is saying. And that's not what civil tort law is intended to do. That's really what the Court of Appeals is saying in Martinez.
Okay, let's hear from opposing counsel. I'll let you go on.
There is my adversary has submitted. Also, my adversary had some, yes.
Wait, let me just double check. Oh, I'm sorry. They didn't appear, I guess.
They didn't appear.
Yeah, all right. Well, are there any further questions? Okay, thank you very much.
Thank you, Your Honor.
We're up to Wong versus Wong. We have to wait for Justice Pitt to return. Okay.
Justice Renwick, did you want to mention that Justice Gesmer is recused?
Yes, thank you. Justice Gesmer is recused on this case.
Good afternoon, Your Honors. This is Dean Cho. Can you see me? I don't
see you yet, no.
I had...
But it's okay, we can hear you clearly, so just go ahead.
Okay. May it please the court, my name is Dean Cho. I am counsel for the appellant cross-respondent Arthur Wong. Now, this appeal I believe can be resolved fairly easily through this straightforward application of the principles of res judicata / merger and bar, which entitled Arthur Wong to summary judgment on his claims and respondent Yudan Wong's counterclaims.
But
in
Mr.
this
Cho,
two-
you know the answer to that you're going to have to deal with, which is that your client was not part of the matrimonial action. I think he went in for a limited purpose at some point. So therefore, she's not asserting an equitable distribution claim here. She was in the matrimonial action. Here, she's saying the apartment is a separate property.
Yes, but Your Honor, first of all, Arthur Wong can invoke res judicata, claim preclusion, merger and bar, because he is in privity. This court, because he is an alleged successor.
He's not in privity. They never, first of all, it was the marital relationship between Kenneth Wong and Yu Wong. And secondly, I don't think that the court found that the property was marital property.
Yes, but that's actually just the point, Your Honors. This court has acknowledged previously in its appellate decision, earlier appellate decision in this case, the lower court itself acknowledged, the matrimonial court acknowledged, and the housing court acknowledged that these issues relating to the legitimacy of the alleged transfers of the co-op shares from Arthur Wong to Yudan Wong were matters to be resolved first in the matrimonial action. And here, Yudan Wong did not obtain a final judgment in her favor on that issue. In fact, there was no such finding, and which means that Arthur Wong prevails because under basic principle of res judicata, where claims arising out of the same transaction have been litigated in a prior action or could have been litigated in a prior action, they are barred. And that's the exact situation here. Under multiple Court of Appeals rulings, In re Hunter, O'Connell versus Corcoran, and Grammaton Home Inventory Corporation.
But I guess I'm missing the part as whether or not you could have been a party to the matrimonial action.
We tried to intervene.
You weren't in privity with the parties of the matrimonial action, so I don't know how you would have inserted yourself in there. And then those apartment shares were never part of the equitable distribution as marital property. I think they were separate property because they were gifted to the husband. And as far as the distribution was concerned, I think the court just included the bank accounts, and the pension.
Your Honor, this court, the lower court, the matrimonial court, and the housing court all have previously said that the issues of the status of the co-op shares was something to be decided in the matrimonial court in the first instance. And because an adverse ruling against Yudan Wong would essentially end the case. Now, moreover, it's important to state at the outset of this case, when we sought to intervene in the matrimonial action, it was sought to overturn the matrimonial court's stay of our housing court action to evict Yudan Wong. Yudan Wong herself argued that there should be a stay because the issues were going to be decided in the matrimonial action. So it was clearly contemplated, and her own pleading below states that that she was asserting a claim that the co-op shares were marital property in the matrimonial action. She never formally withdrew that claim in the matrimonial action.
Yeah, but it wasn't determined in the matrimonial action.
It was determined in the sense that anything that is not deemed marital property is by necessity not marital property. So she had an adverse finding against her. Now she claims in her papers that she didn't actively litigate that issue, but that constitutes a waiver because she could have litigated it. This court, 4 courts have held that she should have litigated the issue of the legitimacy of the transfer of the matrimonial property in the co-op shares in the matrimonial action. She didn't do it. She didn't obtain a valid judgment in her favor. She actually did try to assert that claim. There was questioning in the trial before the matrimonial referee, but he opted not to accept their arguments that there was improper transfer of the co-op shares. So the point is, Kenneth Wong never obtained a valid interest in the co-op shares, which dooms her claim for fraudulent conveyance, because simply you cannot fraudulently convey something you never owned.
Okay, thank you. Let's hear from opposing counsel then.
You're on mute.
You're on mute.
Maybe try it without
Sorry,
the headphones?
Can you hear me now, Your Honor?
Yeah, we can. Yes.
Okay, thank you. Sorry, it just takes a minute for the unmute command to go through.
Okay.
So, Your Honors, may it please the court. My name is Omar Ali from Freshfields on behalf of Respondent Appellant Yudan Wong. Now, Your Honors, I want to address the claim preclusion arguments that were just raised. And I want to begin by emphasizing that before we even get to the merits, the defense was waived. Arthur has never pled the defense, which is an affirmative defense that he has to plead, and he never raised it at summary judgment. And at summary judgment, he had the final decision and order of Justice Kaplan, which conclusively adjudicated the parties' equitable distribution claims in the divorce, but he didn't argue it at summary judgment. And in the 4+ years since, he's never pled it. And so that's a waiver under CPLR 3211. So frankly, we don't even need to get to the merits. But on the merits, as Your Honors correctly noted, there was no identity of parties, which is a linchpin of res judicata, and furthermore, Your Honors. So I understand that counsel
Mr. Ali,
conceded.
can I interrupt you for a minute?
Yes, Justice Moulton.
He only argued claim preclusion, right? Not issue preclusion.
That is correct, Your Honor.
I mean, because I guess if he'd pled it and he argued it below, couldn't this be possibly offensive collateral estoppel in that your client did raise this issue in the matrimonial action and there was a silent adjudication that turned her down? She did ask that it be deemed equitable property, correct?
Your Honor, she did not make that assertion by the time at divorce trial.
But it was in her pleading, wasn't it in her pleading?
It was in her pleading in this case, Your Honor, that she planned to assert it, but that pleading came more than a year before the divorce trial. And as the record reflects, there was no assertion at trial that the co-op shares were marital property. In other words,
Just a second, Mr. Cho,
Yes.
please turn off your microphone.
Okay, thank you. Sorry, Your Honor.
and Your Honor, that's precisely the point, is that counsel has pointed to a number of statements made that before the divorce trial, years before the divorce trial, stating that she planned to argue that the co-op shares were marital property, but she never eventually did. And we believe that that's clear in the referee's report. And Your Honor, we just don't agree that you can have, res judicata requires that the issue be litigated and decided. And it wasn't litigated and decided. And therefore it just doesn't apply here, even setting aside the fact that we're not talking about the same claims here. Moreover, Your Honor, as to the point about the fact that Ms. Wong could have litigated her fraudulent conveyance claims along with her divorce. So the test that is applicable, Your Honor, is not simply whether the claims could have been litigated, but rather under the Court of Appeals decision in Fisher, it's whether they would have formed a convenient trial unit with the claims asserted in the divorce. Because in Fisher, the claims at issue, which were tort claims, could have been, and in fact were asserted in the divorce in the first place, and then they were withdrawn and later reasserted. And the Court of Appeals held that they weren't barred by res judicata because they wouldn't form a convenient trial unit. And we've briefed in detail, Your Honor, why almost virtually every single one of the Fisher factors dictates that Ms. Wong's claims here would not form a convenient trial unit with the equitable distribution claims in her divorce. And I can go through them if Your Honors would like me to or have any questions about that. But on a practical level, I also just want to note that it is not uncommon for parties after their divorce proceedings have concluded and an award has been issued to seek to collect those judgments, in part by recovering fraudulently conveyed assets. And if this court were to hold that parties forego that option, if even prior to receiving a judgment they don't assert those fraudulent conveyance claims, then that would hinder the efforts of many divorce creditors to collect on their judgments. And it's not at all uncommon for divorce creditors to bring fraudulent conveyance claims afterwards, Your Honor. We've cited the Schieffer v. Schieffer case. It's the Second Department case in which that happened. There's the Dempster case also out of the Second Department in which that happened. And then there's the Picaretto v. Murrah case, which is the Fourth Department case in which, again, that happened. And none of those cases found that there was any issue with regards to claim preclusion. Your Honor, I'd like to briefly address the argument that counsel raised about board approval. First, Your Honor, we believe that the cases are clear that a lack of board approval does not prevent transfer of title when it's clear that that a gift was intended and was made, which is precisely the case here, since we have unambiguous documents. Virtually all of the documents affecting the transfer are 100% unambiguous. They state that Kenneth became an owner, and the cases are clear that even if board approval is required but not obtained, that won't stop title from transferring. And furthermore, Your Honor, even if board approval were required but not obtained, it's clear that Hillman waived that requirement. We have at least 3 Hillman officers who signed off on the 2004 transfer, making Kenneth an owner. So even if board approval was required, they clearly waived that requirement. And counsel argues in his brief that Hillman's officers couldn't do that. But Your Honor, we've cited the Odell case, which shows that officers can waive requirements on behalf of the board when they act within the scope of their corporate authority, as Hillman's officers did in 2004 in this case. And finally, Your Honor, Arthur himself consented to the 2004 transfer. In fact, he's the one who asked for it. And that's the 2004 contract where he asked Hillman to make Kenneth a joint owner with rights of survivorship. And Your Honor, because he consented to that transfer, he can't now try to plead it as a technicality 18 years later and say that the transfer was ineffective. Your Honor, if I may, I'd like to briefly also address Arthur's.
You're out of time, so 30 seconds.
Yes, Your Honor, I'd just like to emphasize that those claims are quasi-contractual claims that are barred because Arthur himself admits that he had a contract with his brother covering payment for Ms. Wong's residence in the apartment. And furthermore, Your Honor, this court issued an order or affirmed an order allowing Ms. Wong to remain in the apartment pending divorce. And we submit that it was Ms. Wong's court-ordered right to remain in the apartment pending divorce. So there's no basis for Arthur to try and make Ms. Wong pay for residing in the apartment when she was allowed to do so unconditionally. Thank you.
Thank you. We're back to counsel, Mr. I don't see where you are.
Yes, hi, Your Honors. I'd like to address the various points raised by Mr. Ali. The waiver point, waivering claim preclusion is without basis because he fails to mention this final judgment was not issued until after we had fully briefed the motion for summary judgment. So the predicate for asserting the claim did not exist earlier and obviously could not be included in the pleading. However, the trial court judge did reference the final divorce judgment in her decision, so it's fairly and squarely before the court. Now, the issue of her, whether you, Dan, raised the issue of the ownership of the shares and legitimacy.
So before you move on from that, shouldn't you have moved to re-argue on the issue of res judicata and said, hey, Judge, we want to raise this up now before you? Just her mentioning the decision doesn't mean anything to me because it doesn't give notice. to the defendant that they have to argue the point.
She spent 2 pages of her decision discussing the final judgment in the matrimonial action.
No, but the horse
she
has
had
left the barn at that point. She's made her decision.
Yes,
In other
but
words, Ali wasn't heard on that, or whoever was representing the defendant below.
But waiver is the relinquishment of a known right. We did not know about it prior to the full briefing of the motion for summary judgment. This was an intervening decision, a final judgment that came between the full briefing of the motion for summary judgment and the lower court's issuance of its decision denying us summary judgment. So it just simply could not have been raised before. Now, as to
Counselor, you had 1 minute, so wrap up, please, because that's over.
Oh, Your Honor, it's just that I didn't get to make a lot of my points in the, I didn't get my full 5 minutes initially.
I was timing it. I gave you your full 5 minutes.
Okay.
You can.
As this, there's no denial that this court has said, the Court of Appeals, has said repeatedly that those who are successors to a property interest are deemed to be in privity for claim preclusion purposes. That's the Applied Card and the Buchel versus Bain case. As to their allegedly not pursuing the claims in before the matrimonial court, those were common issues. This court has said that they should have pursued it there. They don't address that point, which we raise in both of our briefs, and they're not litigating as simply constitutes an abandonment of the claim, and therefore
Thank you. You've gotten over 1 minute for sure now. Back to you, Mr. Ali, for 1 minute. This is a cross appeal, am I correct?
It is.
Don't spend the whole 1 minute unmuting.
Sorry, there we go. Your Honor, I'd like to briefly, first of all, address the waiver argument. So the final judgment of divorce came after summary judgment briefing, but during summary judgment briefing, we included as an exhibit to our brief the final decision and order of Justice Kaplan, and that was sufficient for res judicata purposes. And we've briefed this extensively, Your Honor. Under the Court of Appeals decision in Bannon, that decision, which was a conclusive adjudication, was sufficient for res judicata purposes. Arthur had it, but he's never, and he hasn't moved to amend his pleading even now, up until this point. So we've never had notice of this claim.
Mr. Ali, when you say sufficient for res judicata purposes, you mean you can make an argument based on the decision at that point because it's final. That's what you mean, correct?
Yes, Your Honor. I do not mean that it in fact triggered res judicata in this case. Your Honor, as to privity, I'd just like to emphasize that really the theory asserted by Arthur as to being a successor in interest doesn't apply here. Because that theory applies when you have 2 successive litigations about rights to a certain property, and as Justice Frederick correctly noted earlier, that issue just wasn't raised in the divorce, so there's no basis for asserting privity here. And so, because Arthur wasn't a party to the prior litigation, that's just a basic requirement for claim preclusion that he doesn't satisfy here.
Thank you both. We are now on to Mira versus Morrison Cohen. And again, Judge Gessmer is recused from this case.
Good afternoon, and may it please the court.
Good afternoon.
It was error for the Supreme Court to dismiss the plaintiff's breach of fiduciary duty claim challenging their attorney's conduct in 2019. The Supreme Court correctly recognized that an attorney is prohibited from advising a third party adversely to their client or former client on a substantially related matter, exactly as we allege here. So the narrow question is whether the Supreme Court committed an error by dismissing that claim on the basis of a purported waiver contained in an operating agreement of a Delaware LLC, an argument that the defendants raised for the first time in their reply brief below. And that conclusion was wrong. First, there is a standing issue. In that operating agreement in section 11.14, there is a very clear, very broad, no third-party beneficiaries clause. The provision says the agreement can only be enforced by the LLC or its members. And it says the agreement is only for the benefit of the LLC and its members. These defendants are outsiders to the agreement. They're outside lawyers for the plaintiffs and outside lawyers for plaintiff's business partner, Mr. Teller. So under the clear, straightforward language of that provision, they can't enforce any waiver in the section 1111 that the Supreme Court relied on. Getting rid of and rejecting the waiver argument is as easy as looking at those two provisions. And when the defendants raised this waiver argument for the first time in reply below, they didn't flag this provision for the Supreme Court, and the Supreme Court didn't have the benefit of any briefing on the no third-party beneficiaries provision. And I think at a minimum, the interplay of the two provisions creates a question of fact that you can't resolve on a motion to dismiss.
Counsel, can I just ask a question in terms of section 1111, where it does indicate that the services might be for in the future for other members and sometimes adverse. I mean, it makes reference to that. Why shouldn't that be read plainly for what it is?
Well, even if you could parse the provision to get it on its face to apply to this conflict, there's a couple different reasons why it shouldn't apply. One is just contextually, this provision talks about conflicts arising in circumstances where you have a professional service provider giving services to the company on one hand and members on the other. And I think that's how the provision needs to be viewed. What it's not addressing is a conflict arising from a client's own relationship with their own attorney and authorizing that attorney to switch sides and advise someone directly adversely to that client. But even if you could parse it to come up with a reading where it applied to this conflict, you run into the problem of whether it's even enforceable, and there's questions of fact concerning its enforceability, because trying to read it as an advanced waiver of an attorney liability, there's clear fact issues that have to be.
So your argument is at the very least it could be ambiguous and then
Absolutely.
has to go back. Okay.
Absolutely, it's ambiguous. And in terms of reading this as a waiver between a client and an attorney that allows the attorney to later turn around and sue and advise an adverse party how to harm that client's interest under the very subject matter of the attorney-client privilege, I don't think any competent attorney would look at this provision and think, hey, I got a conflict waiver here that lets me do what the defendants are alleged to have done here. And I think resolving the waiver issue in favor of our clients kind of is all that needs to be done. And I think the Supreme Court was pretty correct in recognizing that what we allege here, essentially, the defendant attorneys advising plaintiffs on the drafting of an operating agreement, and then years later turning around and advising Mr. Teller how to harm and eliminate the interests under that very same operating agreement is a very classic breach of attorney's duty of loyalty. And the defendants have raised various alternative grounds to affirm the judgment, but I think none of those have any merit. It's a classic breach. There's been harm, and they are the cause of that harm. They advised Mr. Teller how to come up with the plan to dissolve this holding company. They drafted all the documents to effect it. Mr. Teller himself had no independent understanding of the provisions or how they worked. Everything he did was because Morris & Cohen told him how to do it. And they also advised him that Mr. Teller didn't need to give effect to the plaintiff's economic rights. And as a result, Mr. Teller has been taking distributions for himself since the dissolution without paying plaintiffs their share, causing economic harm. And in addition, as a result of the dissolution, plaintiffs have been deprived of their control, managerial, and voting rights, which is an additional harm. And
Did the plaintiffs ever have their own attorneys at all?
In connection with the drafting of the operating agreement, they were represented by Morris & Cohen. That's the only attorneys that they're alleged to have had in connection with the drafting. And in connection with the events of 2009 and the 2019 that are at issue here, Morris & Cohen acted in secret. They didn't tell the plaintiffs what they were going to do. They didn't tell the plaintiffs that they were going to turn around and advise Mr. Teller had to harm plaintiff's interest under that very operating agreement. And just if there's any question about the adequacy of the factual allegations, we did put forward in connection with our motion for leave to renew a proposed amended complaint based on new facts that came out in a trial in Delaware that happened after the motion was fully briefed, that really crystallized how critical a role Morrison Cohen played in the underlying conduct. They even advised Mr. Teller in an email how to, quote unquote, create the deadlock that was used to trigger the dissolution that caused all the harms.
Okay, let's hear from the other attorney now.
Good afternoon, may it please the court, and let me just thank the court first for its fortitude in staying on the virtual bench for a long period of time. There are several points I'd like to touch on in response to counsel's reply brief and argument, but the primary point I would make is that this court never needs to reach the question of the waiver. It's apparent that plaintiffs commenced this action prematurely, and they've done so before they sustained any damages that are attributable to the defendant's alleged conduct. And they actually concede they still haven't sustained any such damages. The complaint, if you look at paragraph 86, page 43 of the record, says if the Delaware court does not find that plaintiff Mira is entitled to 50% of the distributions, the results will cause plaintiff financial harm. The amended complaint that counsel just made reference to says the same thing. If you look at record 301, paragraph 17, and record 316, paragraph 89. Since they haven't been damaged, they may very well never be damaged. They don't have a cognizable claim for breach of fiduciary duty. Plaintiffs have protested that they're not required at the initial pleading stage to plead their damages in detail. There's no dispute that they're not required to provide what would in effect be a bill of particulars as to all of their damages at this stage. But the case law is clear that when the damages are speculative, i.e. we don't know if they'll ever actually be sustained, that's not enough to get by. And we've cited the Cahan jewelry case and the Eigen versus White case to that effect. Because there are no damages, if the court were to decide that they don't feel it's appropriate to dismiss this case, what they should do is stay it. Counsel rests most of their case on what's going on in the Delaware Chancery Court. It may very well be that the plaintiffs will be made whole as a result of the proceedings in that court. Things of, there were some favorable rulings by the judge there for Mr. Mira.
Can I just ask, with regard to the damages, aren't they saying, maybe I'm confused here, but aren't they saying that but for the plaintiffs, but for the actions of the drafting, I'm sorry, there's a little echo, I apologize, in advising on the drafting and of these certain other documents, that Meta's saying that they would have been able, they wouldn't have sustained damage in the loss of their voting rights or in their control rights or in their distribution rights. Aren't those the damages that they're asserting?
Well, they haven't sustained any actual economic damages yet. But I would also make what I think is a critical point is that the fact that Mr. Mira lost his voting rights occurred by virtue of the documents that were drafted in 2014 that enabled the loss of those rights. There's no timely claim that could be asserted based on what Marlin attorneys did in 2014. Justice Sherwood rightfully dismissed that. That's not been appealed. That's the law of the case. So all that happened in 2019 was to effectuate what was drafted in 2014, which plaintiffs cannot complain about. And we may know at the end of the Delaware litigation whether there are any damages at all, because perhaps Mr. Mira will be made whole because he will have gotten all the distributions he was entitled to. Now,
the holdings, the EOS holdings were dissolved in 2019, right? Were they? The EOS, I'm sorry.
Yeah, that's when the dissolution was declared in 2019, yes.
Right, so I guess they're saying, but for that.
Right, but for that, but we don't know what the effect of that is. Does it cause damages or not? Delaware will be determining that. And what this court has said in Schneider versus Lazard Frere is it makes little sense to go full steam ahead when plaintiff may be made whole in other pending action. So I would suggest that, the proper route here would be just to stay and see what happens and see if there's anything viable as to this claim in the future. But also, with respect to the breach of fiduciary duty count, I would want to say that the only reason that the conduct that's alleged would have been improper would be if Morrison Cohen had obtained confidential information from Mr. Mira that it used against him to harm him in 2019. There's no real allegation that that happened. If he had any confidential information that he gave them, he's the best person in the best position to know whether that happened. He hasn't identified any. He hasn't really alleged that it happened. Under the circumstances, this is a situation that's along lines that were contemplated by the waiver provisions, and it was appropriate for Morrison Cohen to do what really any other attorney could have done, read the provisions that were drafted long ago and determine what rights Mr. Teller had in that regard. And that those provisions clearly, as the Delaware court held, enabled Mr. Teller to declare a deadlock and dissolution, given the fact that he and Mr. Mira could not continue to run the company together. No improper conduct in 2019 has been identified, would be our position. And then finally, can I make one last point?
Yes. Yes.
Sorry. Plaintiff has made reference to the request for leave to amend. I think that should be given short shrift. There was no motion to amend in opposition to the motion to dismiss. After they lost the motion, the case was dismissed. They came up with this amended complaint, but remarkably, that amended complaint just repleads the legal malpractice claim, which was determined to be time barred. They didn't seek re-argument or renewal as to that argument. They haven't brought that up in this court. So the amended complaint is patently improper, and to the extent that amplifies the fiduciary duty cause of action allegations, I would submit that it only confirms that there are no damages because of the fact that the Delaware case remains yet to be determined. Thank you.
Thank you. Mr. Burns, we're back to you for 1 minute.
Thank you. So on the question of damages, I think it's clear that Mr. Mira has suffered damages, is suffered damages, regardless of
Mr. Shapiro, could you just mute yourself, please? That might be a little bit better.
The plaintiffs have suffered damages regardless of the ultimate outcome of the Delaware case. Mr. Teller has taken distributions without paying plaintiffs their fair share, and that's a result of advice he got from Morrison Cohen. In addition, Mr. Mira had to go to Delaware Chancery Court to try to enforce the rights that Morrison Cohen told Mr. Teller he didn't have to honor. And I think this court's decision in Tenzer kind of supports the idea that, when an attorney's actions end up with a client needing to incur additional litigation and expenses, that can be recovered. As to the propriety of a stay pending the outcome of the Delaware action, we would say it's not appropriate, and at a minimum, it should be addressed at the Supreme Court based on a more complete description of where the Delaware action is. As to this point that really the loss of voting rights, it's just all they did in 2019 was just advise how agreements work. Well, they did far more than that. They operationalized the whole thing and put it into action and told Teller how to do it. The idea that anyone could have done it, it's just not an inference that they're entitled to on a motion to dismiss. They were intimately involved. Teller had no understanding of how the agreements worked, and everything he did was because they said so. As to the amended complaint, the only reason that the legal malpractice claim is still in there as a nominal matter, which we explained in our papers on the motion for leave to renew, is because at the time we filed that motion for leave to renew, we still had this appeal and hadn't determined which particular claims to pursue. We're not intending to pursue the legal malpractice claim or the breach of fiduciary duty as to the 2014 or 16 conduct. The only thing at issue here is what Morrison Cohen did in 2019 in secretly advising Mr. Teller.
Thank you. Thank you both. That was the last case for the evening, and court is adjourned. Have a good evening.
Thank you.